Good afternoon, everyone. My name is Meri Ros. I'm one of the partner attorneys over at Rossen Law Firm, and myself and the rest of my partners are going to give you a presentation today about sex crimes. My part specifically is about motions and arguments. Again, by sex crimes, we're referring to not just crimes against children, but also against adults, although the majority of the motions do focus on children because that's just a very specific part of the law. And give you a little background about myself. Again, my name is Meri Ros. I go by Meri. I'm one of the partners here. I'm board certified criminal trial attorney. I have been doing criminal defense for about 14 years now. Spent a large majority at the public defender's office, so I was able to see a lot of these cases, and I have tried several capital sexual batteries in trial, as well as other sex crimes. All right. So when we talk about motions and arguments on sex cases, one of the biggest issues that you are going to be dealing with is called Williams Rule. I'm sure most of you have heard about this. This is actually the state's intent to introduce prior bad acts or character evidence or previous convictions or uncharged crimes. Normally, those are not admissible. So when the state does this, it's generally called Williams Rule. I could spend probably an entire presentation on just Williams Rule. So obviously we're happy to help with any other questions you have in the future. I'll post all my information at the end. Feel free to email us. These slides are by no means completely comprehensive. I'll be going over a lot of things that are not on the slides, and there's a lot of things that I won't even have an opportunity to go over. Williams Rule, which is actually Florida Statute 90.4042B. It's actually the state's intent to offer evidence of prior crimes or bad acts. Now, they are not admissible. Generally in trial, prior bad acts, prior crimes are not admissible unless the state files this. They must, pursuant to the statute, file this no less than 10 days prior to trial. You might think that that never happens. That's incorrect. I had a case where the state filed it 6 days prior to trial, and I did a written objection because the statute is very clear, and the judge did not admit their Williams Rule. Now, when they file this, again, this is going to require almost an entirely new case. Because what Williams Rule is the state is going to try to bring in, so the jury can hear, an entirely different crime. They're going to have entirely different victims that they're going to want to testify at the trial. And obviously, these are prejudicial because you're talking about a molestation case. You not only have the victim on your actual case, but now you're going to be dealing with one or more victims who will be testifying in front of the jury that your client did something to them as well, that the jury is not there to find guilt for. Now, Ms. Lawson, one of my partners who will be presenting later on, she'll be discussing how to attack this in front of the jury. It is very tricky and you must address this. That's why you need notice, because when you have this, you're going to file, like I wrote here, a written objection. Be specific in your written objection. The state, when they file their notice of intent, they're going to throw the entire gambit of the ways that Williams Rule should be introduced here, and I'll go through each one of them. I, in filing my written objections to Williams Rule, go through every single one and attack why it is not relevant to this case. So let's go to the next slide. Now, these are, again, it's at least one of these, but they are not limited to. There's others such as corroboration, which the state always uses, and corroboration is usually one that they can get it under because the victim, when you have a sex case, generally there's not a lot of evidence. I'm sure you'll have DNA, but the majority of the time it's going to be a he said, she said situation. And so when you have a child, then it's generally understood. Children are not going to be as specific, especially if I had a case with a 5-year-old. So a 5-year-old is not going is incompetent to testify by law. So they will bring in sometimes a Williams Rule in order to show that your client did something similar. But the list, and again, it's not an exhaustive list of what they will include, and they're going to include each and every one of these in their motions, in their notice of intent to introduce Williams rule. So the first is that the crime is inextricably intertwined. Now, this is actually used not just in sex cases, although that is today's focus. Anyone who has done Rock court or repeat offender court knows that the state tries to bring in Williams rule for every type of case. One of them is that they say that the previous bad act or the previous crime is inextricably intertwined in order to prove their case. Now, in order to show that something is inextricably intertwined, they have to show one of four things. The first is that the previous crime is necessary to adequately describe the deed. Second is that it's necessary to provide an intelligent account of the crime charged. Third is that it's necessary to establish the entire context out of which the charged crime arose, or number four, that it's necessary to adequately describe the events leading up to the charged crime. The seminal case on this, and I can provide some of these after, is Scott versus State at 957 Southern 2nd, 43, and that's a First District Court of Appeal case from 2007. So, what does that mean? That means that they might try to bring in anything that would lead up to it. So if you have a victim and perhaps her sister claims something happened or that her sister was told something, they're going to try to bring that in as necessary to show the events leading up to it. So in Scott versus State, that was actually a case of felony murder by aggravated child abuse, where the state was trying to bring in evidence that the child had a broken leg, the child was in a body cast. But again, the question is it necessary to prove the crime charged? Because all of these are going to be inherently prejudicial. We're talking about telling the jury other crimes that your client has been accused of, or that your client, or uncharged crimes, or prior convictions. So they really have to be relevant and necessary as inextricably intertwined. In the case of Scott, even though it was felony aggravated child abuse, the court determined that the evidence of the broken leg was not necessary to show because that broken leg happened a month prior and it wasn't actually a part of the murder. Again, the state is just showing that your client is a bad guy. They don't say that that's what they're trying to do, but that is obviously what they're trying to do. And so, and additionally, in Scott, they were trying to show that the child was forced to stand on one leg in a corner as part of the punishment. But again, the court said that's not Williams' rule because that form of punishment didn't necessarily constitute aggravated child abuse. And again, this is a felony murder by aggravated child abuse. So they have to show that whatever they're trying to bring in, that they need it. That basically that without it, they just cannot prove their case or they can't present the whole picture. And we're going to go through this after as well, but no matter what, whether or not they prove inextricably intertwined, identity, absence of mistake, any of those, whether or not they prove them, there's still the analysis of does the probative value, is the probative value outweighed by the prejudice? Because again, if the probative value is not sufficient and the prejudice is too great, even if the state meets any of the prongs, the court can still exclude it as overly prejudicial. I will go back to the slide so we can go through each one, but let me go to the next slide. Now, when you do your objection to the state's notice of intent, again, make it specifically, go through each of the factors because the state will include each factor, although they won't be specific as to why they feel each one is relevant. So for example, if they're saying it's identity, one of the arguments is, look, identity is not an issue. They knew each other. There is not a question about who did this, right? Because it's the child's father. Another one is intent or knowledge, right? Now, they love saying that, well, this is necessary to show the intent. This is necessary to show knowledge. However, the majority of sex crimes, such as lewd and lascivious battery or sexual battery, lewd and lascivious molestation, those are actually general intent crimes. They are not specific intent crimes. So I write in my objection, intent and knowledge, they're not issues in this case. The fact that they don't know what they're doing is wrong, that's not an argument. That's not a defense, right? We all know that it doesn't matter if the child came on to you, if the child wanted it, if you didn't know it was a crime, if you weren't aware of their age. Those are not necessary. Those are not defenses. So for them to try to bring in priors just to show that they knew that this was wrong is irrelevant. And again, the probative value has to outweigh the prejudice. And one of the cases for intent just to show whether it's a specific intent or a general intent crime, is Buford versus State. That's an old Florida Supreme Court case from 1986 at 492 Southern 2nd, 355. For the next one, and again, I'll go back to the list so we can. All right, just so you understand, once you file your written objection, then there's going to be, you're going to request a hearing. I request a hearing in my written objection, as the state at that point will have to list their Williams Rule witnesses, who they intend to call to show these priors. And then you take their deposition. In Florida, we're allowed to take depositions, so that's what you do. You treat them as any other testifying victim, because that's what they will be. Although the jury consider them as victims, they're going to testify as victims, and the jury will hear it as such. So you take their depositions, you do your investigation on these witnesses like you do everyone else. And once you take their depositions, then you have this hearing to determine, again, the state has to show by clear and convincing evidence whether or not they meet any of these. All right, so for a Williams Rule hearing, before the Williams Rule evidence, it is incumbent upon the trial court to make multiple determinations, and these include: one, whether your client actually committed this prior crime. Because again, we'll go over a little later, this doesn't actually have to be a prior. These can be uncharged crimes. In other words, a victim can come out of the woodwork and say, look, I never even went to the police about this, but your client molested me when I was a child as well. And obviously the jury hears this and it's very prejudicial. So the court then, at the Williams Rule hearing, has to determine if it's an uncharged crime, no prior conviction. They have to determine by clear and convincing evidence whether your client actually committed this prior crime. This isn't beyond a reasonable doubt. This is clear and convincing, higher than preponderance, lower than beyond a reasonable doubt. Number two, whether this prior crime meets the similarity requirements necessary to be relevant. And again, those similarity requirements are what that previous list was: intent or knowledge, a common plan, opportunity, absence of mistake. The biggie is modus operandi. I'll go over that a little more, but the court has to determine whether these are actually similar enough. We'll find cases where they say, well, it was too long ago, or the ages are too different, because if one is a 5-year-old or an 8-year-old, and then the testifying victim for Williams Rule is 16 years old, that's a big difference. Because again, as far as modus operandi goes, the state's trying to say your client is a child molester, a 16-year-old is charged as unlawful sexual activity with a minor versus a capital sexual battery for a 5-year-old. So you as the attorney must distinguish all of these to the court. Make them as different as possible. Number three, whether the prior crime is too remote so as to diminish its relevance. Again, something happened 10 years ago, and someone comes out of the woodwork, they never went to the police, and 10 years later they're saying this happened. That's too far away. And again, not only does the court have to determine whether they actually committed this crime, why wasn't this reported, but something that happened 10 years ago, how much probative value is it really going to have as far as this case goes? Again, it cannot be that the state is proving your case only through Williams Rule. That is only if they're going under the inextricably intertwined, but that means that it is absolutely necessary to prove their case, that they cannot prove their case without it. And finally, no matter what, one of the determinations is whether the prejudicial effect of the prior crime substantially outweighs its probative value. This here is your money argument. This is always where you're going to be focusing on. As rates of recidivism for child abusers, child molesters, everyone knows that those recidivist rates are very high. So when a jury hears that your client has done this before, the evidence that they have in the case in chief is not really going to matter. And although they're not supposed to convict based on Williams' rule, they will. We all know they're humans. So again, this is one of the reasons you really have to voir dire a lot if there's going to be Williams' rule evidence. And so again, as mentioned before, whether evidence can be properly admitted as Williams' rule is highly individualized, factually intensive inquiry. There are lots of cases for Williams' rule. It's called Williams' rule because of 1956 case, Williams v. State. The cases that people really cite to now are McLean for child abusers or child. So I said earlier, you really want to focus on the differences between those crimes and the current. So if in your case, your client is charged with a molestation, lewd and lascivious, against a child, and they're claiming that this was grooming. Grooming is something that you see a lot in child molestation and sex cases involving children. And if there's grooming, that's very, very specific. That is, psychologically speaking, something that child molesters are known to do. So if you have someone coming out, I had a case where there were two victims, and then there was a third one, which was Williams' rule. Victims were his twin daughters. The Williams' rule victim was a cousin. The way it happened with the daughters was very similar. They were charged separately. They were Williams' rule witnesses on each other's cases. They were twin girls, and really the molestation charges were almost identical. We had the full hearing, but it was impossible to keep that out. What we were able to successfully keep out is the cousin, because the cousin's case was very different. There was no grooming. With the twins, it was that it started when they were 10. It started off as touching, then it turned a year later into anal sex, then into vaginal sex. There were Bible verses that were quoted, really very identical fact patterns. However, for the cousin, it was a forcible rape that's in a car in a parking lot. So we were arguing, look, if you want to charge this, it has to be a separate crime, which they ended up not charging it, but that it could be used as Williams' rule evidence because it was completely different. I mean, yes, they were both of minor children related to him, but one was a single encounter in a car that was violent, it was forceful, while the other ones were grooming. It took time, it was over the span of years. So again, it is a very factually specific inquiry that you have to go through in the case and show, as the attorney, as the defense attorney, you have to highlight all offenses. Again, where the conduct occurred, right? Was it a parking lot or was it at their house? The age of the victim. Again, because if the modus operandi that the state is suggesting is that your client likes them very young, under 12 or I'm sorry, 11 or under for capital battery, and they try to bring in a 15-year-old, a 14-year-old, again, we're going to say that that's not enough. And judges know, and you have to argue it, that really what the state is just trying to do is show your client's a bad guy, to show that your client just intends to molest children is what they're trying to show. The burden of proof. So again, it's the state who is trying to assist. It's actually whoever is offering this evidence. The offering party is the person that has to show that these prior acts by clear and convincing. And the reason it says the offering party and not just specifically the state, defense attorneys can also do Williams' rule. I've done that before. It's called reverse Williams rule, where you're trying to bring in that this other person has, that this victim has lied before, or that this victim has done other things before. Again, Williams' rule is something that you can both offer. It's usually done by the state. I'd like to throw that in there, but that would be an entirely separate presentation on reverse Williams' rule. But this is the McLean case that I referred to before. And again, this is that the offering party must prove that the person committed the collateral acts by clear and convincing evidence. And so here we discuss Alspeed. Alspeed is where the trial judge heard testimony that the defendant sexually assaulted her. They did allow the Williams rule in that case. However, the appellate court found that the victim's story was actually not credible, the Williams rule victim. It's actually not credible because, again, the defense attorney got out that this person had given different accounts to the police, that ultimately filed a waiver of prosecution, that the story had changed over time. And again, because of all of that, the trial court did allow that evidence in. Are going to be facing an uphill battle. Trial courts tend to allow Williams rule in, especially on sex cases. They're a little tougher on non-sex cases, but in cases involving children, because children are kind of inherently unreliable and they are not that specific, they do tend to allow Williams rule. Again, you have to file your written objection and you have to lay that very, very clear record because this is going to be an appeal. And really, half the time when you're arguing, when you're filing your motions, you're really addressing the appellate court because you're kind of assuming the trial court is going to get it wrong. So in that case, the trial court did get it wrong. So what kind of prior bad acts can the state use? So what about if it did not result in an arrest or prosecution? Yes, they can still bring that in. They can bring it in even if they never went to the police. And what if it resulted in a null pros? Yes, they can still bring it in because a null pros can happen if the victim becomes unavailable or they change their mind, and not necessarily because the state determines that the victim is unreliable. Can the state use collateral prior bad acts which were prosecuted, but your client pled out to a lesser, maybe a non-sex offense? Yes, I've had that happen. My client was on probation in Palm Beach for 2 victims. They were charged with sex cases. They pled out as child abuse. Then he was charged with the cousin down in Broward County. And we had a full Williams rule hearing. And yes, the judge did allow the testimony. However, he did limit it to just the portions that were similar, because in those cases, they were actually very similar, but there was force used, not one in the other. But it did not matter, legally speaking, that our client was not actually a sex offender. Can the state use collateral prior bad acts which were prosecuted but resulted in a not guilty verdict? No. So if a jury acquitted your client of the prior bad acts, no, the state cannot use those because the jury found your client not guilty. And here are just some additional cases that you can take a look at. Before we go into Rape Shield, I just wanted to go back into some of the other common plans and things. So again, we went over inextricably intertwined, same as identity. Now, absence of mistake. This is one, it's in there, it's absence of mistake or accident. I know when they're saying that this could happen, it's so rare. So absence of mistake, this would really be, I actually did have a case like this where the client claims that they were sleeping and they rolled over. There was the child next to them, and the child claimed that she woke up and that he was rubbing on her vagina over her underwear. So the fact that he had been asleep, the child had been asleep, theoretically, you can argue, look, the person was dreaming, or the person didn't realize what was going on, or maybe they thought it was their spouse in bed with them and not the child. So in cases like that, yes, theoretically, that could be a defense of mistake, a defense of accident. And so in those cases, the state might try to bring in a Williams rule victim to show that, in fact, your client has done something like this before, that it can't be a mistake because this has happened before, because this is a pattern. Now, the easiest way to attack this is, well, our client is accused of touching them inside of their underwear or penetrating their vagina with penis or with fingers. In those cases, mistake, accident, those are not defenses. No one's going to think that the person, held them down and forcibly had sex with them by mistake or they were dreaming. So those cases generally don't come in under absence of mistake. For opportunity, again, they try to bring this in, right? Family members saying that, oh, they've done this before. This is to show that they have the opportunity to do. Again, the easiest way to attack this is that the person that your defendant had unfettered access, right? So whether it's a family friend, whether it's a parent, or whether it's anyone who had been at the home before or at the place that this occurred. Again, opportunity would not be an issue in those cases, so it's disingenuous for the state to claim that they're trying to appeal into a victim for opportunity. So I had a case where it was, someone in the church. In those situations, it was a family friend. They saw each other at the church all the time. He went over to the home constantly. Opportunity was not an argument that the state could make because our client had unfettered access to the victim. As far as preparation or plan, is rarely seen. It's also called a common plan. I have not experienced those personally. That's usually with multiple defendants or to show maybe rope, to show that this is something that, again, preparation and plan can go hand in hand with modus operandi. All of these really are related, and when you do your arguments, you're going to be referring to all of them. Common plan or common scheme, again, you want to highlight the differences. In this case, showing that this was a plan, showing that there was preparation is not a necessary element, or that the other case is different. Again, when it comes to modus operandi here, this is easy, right? This is their MO. This is what this person does. But to show MO, you have to highlight all of the differences, right? So I had a case where they called him the Candy Man just because he sold Amway from his van in this neighborhood, and he would give the families chips or candy. But with one of the Williams Rule victims, he wasn't known to go to his van. This was alleged to have taken place in the home. So that one we were able to exclude because the MO was completely different. Even though they were similar ages, even though it was in the same neighborhood, even though the sex acts were very similar, the way it was carried out, the modus operandi, was different. So we were able to exclude that. Because remember, what you're arguing, this is a separate crime. This is a separate act. If the state wants to charge your client with that, they can. But we are talking about uncharged, about them bringing in a testifying witness in front of a jury is going to talk about another crime that they're not currently being accused of, that they're not currently being convicted. So it's not enough for the state to just say, look, it's clear and convincing that he did this other crime. They have to show why it is necessary, why they need to bring this in on your case, why it's going to be so probative that even though it's going to be prejudicial, that the probative value is so great as to outweigh the prejudice. And again, as far as knowledge is not an issue on most of these cases. Knowledge will be more for the adult cases because for children, it doesn't matter whether you know it's a crime, if you're from another country and over there it's not a crime, here it is, doesn't matter. The minimum mandate, you're still going to be prosecuted. So the big takeaway, let me just go forward a little more. Big takeaway for Williams Rule out of everything. And again, I could do an entire presentation on just Williams Rule. It's very tricky, and you are going to see it very often in molestation cases. This takeaway is they have to file their written notice telling you more than 10 days prior to trial, telling you specifically what they're intending to prove. They will generally do the catch-all list. You should file your written objection, demand a hearing, take their depositions, do your investigation as if they were separate cases, as if they were separate victims. Our founding partner, Adam Rossen, is going to speak after I do. He's going to go into investigations in sex cases. So in that presentation, keep in mind, you're going to be investigating all of the Williams Rule victims as if they were separate victims, because that's in essence what they are going to be as far as the jury is concerned. So with Williams Rule being covered mostly, let's talk about Rape Shield. Now, Rape Shield, I'm sure a lot of you have heard about Rape Shield. Rape Shield, I've mostly seen Rape Shield when it comes to adult cases. It's a newer law. And you really should keep Rape Shield in mind, especially now we live in a post-Me Too era. So this is a biggie, and the state will file. They're going to try to preclude you from bringing in anything, right? They try to keep everything out, and then it's your job to bring in what's necessary for your defenses. And I should also add that if anybody has questions, just type them in. I'm going to save the last few minutes of the presentation for questions, okay? So this is Florida Statute 794.022. And this is specific instances of prior consensual sexual activity between the victim and any person other than the offender cannot be admitted into evidence in a prosecution for, again, the statutory crimes of sexual battery or child molestation or lewd and lascivious. And again, it's important to note here that the statute says there are instances between the victim and other people, not the offender, right? Because other instances with the offender can be included. Again, the state's going to say, all of this is to show that what the defense is trying to do here is to show that the victim was a slut, right? Slut shaming. That's not admissible. You're not allowed to say, well, your victim here likes to go to nightclubs and pick up strange men, and that's how it happened on your case. Well, that's what the state's going to say. But again, we're going to cover how you can bring in some of those if they are specific to your defense. Now, this is the however, right? However, such evidence may be admitted if it is first established to the court in an in-camera proceeding. So when the state files their Rape Shield preclusion, you're going to request, if there's things that you want to bring in that the state is seeking to preclude you from bringing in, you're going to request an in-camera hearing. And in that in-camera hearing, you can show, you can bring in certain things to show two big things. One is consent, and the other is to show another person committed the crime, right? So the first is you can do an in-camera hearing to show that such evidence can prove that the defendant was not the source of the semen, pregnancy, injury, or disease, or when the consent of the victim is at issue. Then such evidence may be admitted if it is first established to the court in the in-camera proceeding that this evidence tends to establish a pattern of conduct or behavior on the part of the victim, which is so similar to the conduct or behavior in the case that is relevant to the issue of consent. Okay, so let's break that down. This also says, notwithstanding any other provision of the law, reputation evidence relating to a victim's prior sexual conduct or evidence presented for the purpose of showing that the manner of dress of the victim at the time of the offense incited the sexual battery may not be admitted into evidence in a prosecution. This has been around for a while. You can't, basically this says, you can't say, well, she was wearing a short dress, she was asking for it. Okay, so let's talk about how you can get around Rape Shield, how you can bring it in when you show that it's specific to your defense. If you're arguing consent, right? So these are in adult cases where, yes, your client is saying, look, she said we could have sex, victim saying, no, I didn't. In showing whether consent is a defense, the state can bring in the victim's mental incapacity or defect, right, to show that it was not a knowing or voluntary consent. This is the victim was too drunk to consent, right? The state can bring that in when you're having, again, you'll have your in-camera hearing. You're saying, well, judge, we're going to present evidence that, she was kissing him at the bar. Witnesses were seeing this. But then again, the state can say, right, and we're going to bring in evidence to show that right before she did all of that, she had 10 shots back to back to back, or that possibly she was drugged. And that's where they might try to bring in a toxicology report. Also, if the victim on a rape case, on a sexual battery case, does ask your client to use a condom or any other type of prophylactic device, that does not mean that it's consent, and the state will preclude that. Will not allow the jury to hear that she said, please wear a condom, because it's not considered to be relevant to the issue of consent. Now, I cited this case here. This is Visa v. State at 489 Southern 2nd 36. It's a 4th District Court case from 86. Now, in that case, it was a child that was accusing her stepfather of sexual abuse. And the defense was trying to bring in the mother's testimony that she actually walked in on the child in bed with her brother, and that the brother was, and that the other person was nude. And so in that case, even though the child victim during the sexual assault examination was determined to have injury consistent with sexual battery, consistent with rape, the question of how that injury was caused and who caused that injury, that was the issue, and that was the defense. And in that case, the court determined that, yes, the mother's testimony that the daughter was in bed nude with her brother supported the reasonable inference that it was actually the brother, not the stepfather, that caused that physical trauma that was later identified. And so this was evidence that the jury should have heard. So again, don't be intimidated because the state files their rape shield preclusion and tries to prevent you from bringing it in. That's their job. That's what they're going to try to do. They want to handicap you and they want to cut off your defense at the knees. But again, all of these are very fact specific. You should have an in-camera hearing and try to explain to the judge why your evidence is in fact relevant, and that you're not trying to victim shame, that you're not trying to say she was asking for it, that this is a relevant and necessary defense. In this case, it was necessary to show the identity of the perpetrator. So certainly that she was in bed with someone else was completely relevant. And so in this other case, this is Dixon versus State, 605 Southern 2nd. I have the cites here. That was a 5-year-old victim. And again, with 5-year-olds, it's very tricky because they are given a lot of leeway. You will see that normally in any other crime, you will have a very specific information that states what date it happened, right? And it has to show with specificity what date it happened. But with child victims, the law is a little more lenient about that. They are allowed to give for a one count, to say it happened sometime in the summer of 2021. In adult cases, you're going to have to be a lot more specific, but with a child victim, they are allowed to give them more leeway. Now, in this case, though, it was a 5-year-old who actually had a lot of knowledge, had a lot of sexual knowledge. She knew the terms. She knew a lot of things that most 5-year-olds don't know. And so the defense in that case was fabrication. And so the court did rule that the evidence of the child victim's prior sexual knowledge, that was impermissibly excluded under rape shield, that the jury should have been able to hear that this child knew that. Why? Because again, everything is fact specific. In that case, you have a 5-year-old. If a 5-year-old starts using words, adult words, the jury is going to think, oh, they learned it from their client. They learned it because of this crime. That's how they learned all of these terms. And in fact, in Dixon, it was determined that that child actually knew all of that before. So that should have absolutely been brought in front of the jury, because the defense in that case was that the kid was making it up. So just because the kid knew certain terms, that doesn't mean that it was your client who was teaching her that, especially if you have evidence that this child, that's how they talk. And again, you just have to have the in-camera hearing, but you absolutely should do the in-camera hearing because otherwise you're not going to be preserving it for appeal. And so then we have Thorne versus State. Now, in that case, it was exclusion of evidence that the minor victim, during an interview, had accused 3 other men of sexually battering her and didn't actually accuse the defendant at first. That came after. So prior false accusations is what that case is about. And the theory of defense in Thorne was that the victim fabricated the allegations after he stopped giving her gifts. And so basically she was mad at him. And so she said, well, he raped me, right? So in that case, the evidence that she had falsely accused or that she had previously accused other people and those were not prosecuted or she took those back, that the jury should have absolutely heard it. Again, because the defense in that was fabrication. You have to explain to the judge how this is necessary for your defense. Obviously, defense's theory of fabrication, it is absolutely relevant that she didn't point the finger at your client first, that it was actually someone else. Or, for example, how the victim said it happened, right? How did the victim first accuse your client? So I had a case where it was discovered through depositions that it wasn't actually the child who said that our client, who was the neighbor, right, that our client touched her. It was only after the mother asked the child, who did this to you? How did you learn this behavior? Because that child was touching her baby brother, babysitter saw it, so babysitter tells mom, mom freaks out. You know, how did this young child learn this behavior? And then the father says, oh, she told me it was our neighbor. And because the child looked at the father when she was first asked this by the mother. And the state actually ended up dropping that case because they filed on it. I got him out in the Arthur hearing. I said, look, Judge, the identity is absolutely an issue here. You know, I think it's the dad. And the child looked at the dad when she was asked who did this. So again, all of that, right? All of that would be relevant. In that case, it did not go to trial. Luckily, I had a reasonable prosecutor who agreed that it was the father who put it all in her head, that it was our client, the neighbor. But that's something that the state absolutely wanted to keep out. Okay, so this is the last part of the presentation, which is child hearsay. So obviously this is not for adults. This is specifically for children. Under 16 is the law. So, okay. For hearsay, so obviously we all know hearsay is not normally admissible. Like I said earlier, when it comes to children, they are given a lot of leeway, and child hearsay can be admissible. Again, the state has to file their motion for child hearsay. You'll have a hearing, and we're going to go into that. But basically, for hearsay to be admissible under the child sexual abuse exception to hearsay, 2 things have to be shown. Both have to be shown. First, that the source of information through which the statement was reported has to be trustworthy. And second, that the time, content, and circumstances of the statement must reflect that statement provides sufficient safeguards of reliability. So what are we talking about here? 2 things. Both have to be shown. Trustworthiness and reliability, okay? So what you are looking at here, what your focus should be, is this source of information, right? Who is going to say what the child told them? Is this going to come out through a video? Is this coming out through mom saying, well, you know, she woke me up in the middle of the night and told me that this person molested her? So you're going to look at trustworthiness and reliability. Now, this is Florida Statute 90.80323. This is the child hearsay exception. It is a very limited exception to the hearsay rule. It is only for child victims, not for any general witnesses. It can apply to any type of abuse, so it's not just sexual abuse. It can also be aggravated child abuse or anything else of that type. And again, just like the Williams rule notice, the state must give you written notice no later than 10 days prior to trial. When you get this, object. Now, for child hearsay, you don't have to do a written objection. you simply ask for a hearing to determine the child hearsay. Okay, so what children qualify? It used to be that it had to be 11 and under for the child hearsay to be admissible. The law changed to the child only has to be 16 or less. Now, this can be the physical, emotional, or developmental age of 16. So I actually had a jury trial on an aggravated battery. It was an adult victim. However, she had the emotional intelligence of a 13-year-old. So in her case, they did attempt to bring in the child hearsay. I successfully was able to keep that out. But that was a big hearing. And the big reason was because the source of the child hearsay, the person who was going to testify about it, was not her case manager. It wasn't anyone that might be deemed trustworthy. It was her current boyfriend. So, that seems untrustworthy. So I told the judge, look, in that case, it was a testifying victim. She can testify to whatever she wants, but we can't now have her boyfriend saying that, well, she told him the same story. That would just be to corroborate it. That's bolstering, and that's completely improper because how trustworthy is this person? This person hasn't had any kind of training in how to question a child. That's really where you get into the reliability factors as well of child hearsay. So just specifically as far as the rule goes, the child has to either testify or be unavailable for the testimony. For unavailability, that has to be a finding by the court that the participation in the trial or proceeding would result in a substantial likelihood of severe emotional or mental harm. Now, for that, when it comes to emotional or mental harm, there are other safeguards that can be done. The child's testimony can be videotaped and then played to the jury. Ms. Lawson is going to go into a little bit of that. But there are other ways to do this rather than have the child not testify at all, because then the jury is hearing it from a third party. And, again, how reliable is that testimony going to be? You're not actually hearing from the victim, you're hearing from a third party. Or, in the inverse, if the child is going to be testifying, then the question becomes, why do we need this other testimony? State's going to say it's to corroborate the child's testimony. And here's where you have to look at, okay, if it's a 5-year-old, yeah, that makes sense that they would want corroborating testimony because 5-year-old's not really going to stand up to cross. However, you have a 15-year-old or a 16-year-old, right, who's going to testify. They're a testifying witness. Do we really need to hear the same story being told over and over again, no matter how reliable or trustworthy that source is and how that testimony is? That's just bolstering. That's just going to get the story out in front of the jury many, many times. And again, you're going to be arguing that that's overly prejudicial, and it's not necessary to prove the state's case. So that's something you want to watch out for bolstering and cumulative evidence. Again, set a hearing, object. And even if the judge does allow it, remember to renew your objections at the trial. All right, so when we're talking reliability factors, again, during the child hearsay objection hearing, that separate hearing that you're going to have prior to trial to determine if that child hearsay is going to come in or not. You're going to attack, well, not attack, but you're going to attack the credibility of the person who is testifying. So is this, usually it's going to be a parent or a teacher, or it'll be the CPS worker, the Child Protective Services worker. So I had a hearing where it was a Child Protective Services worker, and a lot of people think that just because it's a CPS worker, that they are trained, that it's going to come in no matter what. In the trial that I had, it did come in. I don't agree with the judge. We ended up winning that case, so we didn't have to take it on appeal. But it would have been a good appeal because the CPS worker in that cross-examination during the child hearsay objection hearing, they are trained that leading children is very dangerous, right? So children are going to want to please authority figures. So if it's a police officer who is questioning them, because again, we're talking child hearsay, we're talking, is the police officer going to say, yep, this is what they told me happened? Is the parent going to say, this is what they told me? CPS worker, this is what they told me. Is that coming in? Well, how is that information relayed, right? because in the hearing that I had, the CPS worker was specifically trained that you cannot ask leading questions to a child. But you could see in the interview that she was getting frustrated, and what she was trying to get out is that there was blood on the sheets, right? This was a forcible rape on a 10-year-old, where she was tied up and she was a virgin. So presumably a grown man who forcibly rapes a 10-year-old, there's going to be blood. There's going to be physical evidence on the bed sheets. And that's really what the CPS worker was trying to get out. And this child was just not saying it, was not giving her the answer that she wanted. And again, she was pushing and she was saying her original questions were proper. They were open-ended. They were, okay, how were you feeling? What did you see? But when she wasn't getting the answers that she wanted, she was saying, okay, well, was there anything on the sheets? The child was still not saying it. She said, is there any blood? And again, all of those, maybe not normally leading questions to an adult, but for a child who is inherently very suggestible, especially when it comes to an authority figure questioning them, these questions are dangerous because a child is asked the same question over and over, they're going to give you the answer that you're looking for, whether it's a parent, but particularly if it's someone in a position of authority, like a police officer. So be very careful with the videos, and they're going to be videotaped, whether it's CPS or if it's police, but scrutinize those. What questions are asked? Is the same question asked over and over? Is it asked in different ways until they get the answer that they want? It should be asked once, and they need to take that answer as it is. Again, especially if the child is testifying. The child's going to say that this happened, so we're going to allow the jury to see this other interview and hear the same story over and over again, even though they were leading questions? I don't think so. And if it's a parent, all right, well, when was this told to the parent, right? I had a case where the child had been getting into a lot of trouble at school, and the parent was asking them, what's going on? Why are you doing badly in school now? Why have you been getting detention? And then that's when the child said, oh, it's because I was raped by this person. So how reliable is that? How trustworthy is that? Is it because the child was trying to get out of being grounded by mom and dad in saying that, look, the reason I've been failing my chemistry test is because I'm actually having PTSD from this rape? Or is it because the mom kind of put it in their head? Again, just like the story that I told before about my client who accused the neighbor, it wasn't her that accused the neighbor, it was her father who accused the neighbor. And again, all of this is not going to be in the state's case in chief. You're not going to get this in a police report. This is you having to do your due diligence. And in these cases, you must have a hearing. Okay, and that puts us at 12:53, so that was actually a couple minutes earlier. So at this point, if there are any questions, I can take them now. Looks like I don't see any questions, so here's my contact information. Again, you can scan that and get all my contact information. I'm happy to help out. Criminal defense community is a small community here, and we support each other. So if you have any trials or weird fact patterns, you want to call us, I'm more than happy to help answer any questions.
All right. Hey, everybody. I'm Adam Rossen from the Rossen Law Firm, and we just were able to listen to Meri talk about some great things on these cases. And I'm here really to talk primarily about the investigation stage. What do we do, right, as criminal law practitioners when we have a client call us or come into the office and talk about being, either investigated or arrested for a sex crime. And we'll talk a little bit about the investigation stage, that process up through filing charges. And then we're going to fast forward a little bit and talk specifically about the deposition process as well at the second half of my presentation. So with that, let's begin. Now, who am I? So I'm Adam Rossen. I'm the founder and CEO of the Rossen Law Firm. We handle criminal DUI defense, sex crimes, white collar, pretty much anything criminal related. And there's my little bio about me, but you can definitely take a look and read that and hit the QR code if you'd like. But really, this is not about me. This is about you folks and really just educating and talking about, the best way to handle these cases and have a successful outcome for our clients. So, as I said before, really the order of, investigations and really not further than just investigations, but just sex cases, right? Usually there's a police investigation that starts with number 1, and 2 and 3 can be reversed in some situations. So, and I'm going to go over that, in a few minutes, but it could be the prosecutor could make a filing decision, which can then lead to an arrest and a surrender, or after the investigation, the police will then make an arrest, or we will coordinate a surrender, which will then lead to a prosecutor's filing decision. So 2 and 3 can be be interchanged, and then we go through that discovery and deposition process, which is most of the time the longest process in these cases, and then the last stage would be a plea resolution or a trial stage. So really that's the basic general order. Not too different in order than most criminal cases, except for the vast majority of criminal cases that we see, there's an arrest made immediately on scene right away, where in these sex cases, the vast majority of cases, there's an actual time extended timeline where there's supposed to be an investigation. Of course, we always say supposed to be because as most criminal practitioners know, the police don't do good or detailed investigations in most cases. Now, the client interview. So this is essential. When you first meet with a client, this is a golden opportunity to be able to influence the case against your client from day one. And above all, you must establish trust with that client. In any type of case, but especially in cases as severe, as sex cases, right, where there's literally the client's entire future could be in your hands. So you must establish that trust. You must get the client to be honest with you, to be opening up and giving as much detail as possible. Now, the first thing you need to really ascertain is, has that client been arrested and charged, or have they, just been contacted by law enforcement, or have they not even made contact or been contacted by law enforcement? But if they have, you need to know who, right? Who made contact with the client? You must get the law enforcement officer's information as soon as possible. As you may know, police officers are allowed to lie to their suspects, our potential clients. They're allowed to pressure them in some ways, and they often do in these cases. So we must make contact immediately, right? We need to discuss with our client, well, what evidence do they have, right? What evidence needs to be preserved? Are there cell phones? Are there text messages? Are there videos? Right? All of these things that may, are there witnesses? Who are the players in this? We need to get all of that as soon as possible. The next thing is, well, what evidence, right, would we maybe need to subpoena, right? So as we're talking about certain things like, again, text messages, videos, maybe social media messages and back and forth, we want to screenshot it to really preserve it, but then do we need to actually subpoena this from the company to make sure that we can get that either now or later, possibly at a trial or throughout the case. So, and deciding when to do those things, because there's strategic advantages and disadvantages of getting a subpoena too soon. And really, who else was involved that needs to be investigated? Start building your theory. So is this a situation where the couple is going through a divorce, and all of a sudden, 5-year-old Johnny is claiming that, or mom is claiming that 5-year-old Johnny said that daddy touched him in an inappropriate way, but really mommy wants to move with her new boyfriend, 5 states away, right? So, we need to discuss theories of this with your client to see, well, hey, do we need to investigate mommy and her new boyfriend and find out, what are the real reasons of this? So all of those are extremely important. And when we have the client interview, it's all about collecting details. So classic, who, what, why, when, where, how, right? Just basic questions that we learned in grade school. But We're going to want to know, right, again, why were they charged? What were their theories? Where did these things take place? Right? Was it at your client's house? Was it at somebody else's house? Was there anybody present that could be a witness, or could be either a witness to the allegations or a witness to say, hey, I was there. Nothing could have possibly happened because there were 7 people in a 700 square foot apartment, and we surely would have known if something happened, right? Okay, when and building that timeline is so important. Is this a late report? Is this something that happened, years ago, right? Is this something that happened recently? When did our client become aware, right? Is the client still in touch with the alleged victim? All of these things are very important for understanding our strategy throughout, especially throughout the investigation stage. Are there any documents, right? Does the client have anything, related to the investigation or charges, any kind of documents whatsoever? Again, it could be something like an email. It could be a lot of different things. Is there maybe, was there any documents or messages passed back and forth, or even, we've had cases where a diary was kept, right? Is there something like that where there's a diary? And where is your client in the communication with law enforcement stage? Was your client at work and a cop, a sex crimes investigator came and left a business card and, on his door, and he came home and saw that? Or did he have a full-blown conversation over the phone? Or did your client already go in and give a statement, right? You need to know exactly how much has already been done, because sometimes our clients, they have great intentions, but they often, make tremendous mistakes in their case. And you must let your client know immediately, no more. Everything runs through us. Everything, every strategic decision, every communication with law enforcement, any communication with outside people, they need to understand to watch their text messages, and just, this is not the type of situation where your client needs to be talking to multiple people about this and about what's going on. You need to make that very crystal clear from the beginning, right? Now, you also have to set client expectations, and that's kind of what I was going about and really talking about, up until now, is just making sure the client understands who's in charge. Okay, client plays a very big role. The client and the attorney are partners in this, but the attorney needs to be the one steering the ship, needs to be the one making the final strategic decisions. But as in things, in all walks of life, communication is key. And I believe the attorney needs to effectively communicate with the client and explain, this is the plan, this is what we're going to do, how we're going to do, why we're going to do it, especially the why, and make sure that the client's on board and there's that trust and give and take. And as far as, what are we trying to do during this investigation period? So number one whatsoever, no uncertain terms, is you must be that buffer, that shield between, your client and law enforcement, okay? At our firm, we kind of equate it to being Captain America. Captain America's weapon is his shield. And we tell clients, we are your shield. Everything runs through us. We want all communication. We are shielding you from law enforcement. And then again, as we stated, gathering the essential information. Those are the really two. So as we talk about shielding the client, right, they have a right to remain silent. They have a right to counsel. And what we do at our firm is we've seen over years and years, and I was a former prosecutor, that in most situations where it's really, it's really concerning that law enforcement may be lying or may be exaggerating, usually it's about either probable cause to search or start, to search, or it's about what a client said to them, right? Maybe this was an excited utterance, or, as they made initial contact before a body camera was on or before there's a statement at the station. the client said, I know why you're here and blah, 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 right? And so what we do to combat that is we give clients an invocation of rights sheet. Basically where they're able to very easily invoke their right to remain silent and right to counsel. And all it is it's a sheet on our letterhead. It has all of the attorney's names. It has our office number, which is answered 24/7. The client signs it. And that way, we don't have to really stress or worry. The client's instructed to just, if something happens before we can prevent it, or without our knowledge, the client can just hand that over and give them the invocation of rights form and just say, no, thank you. And now we're creating evidence. So instead of, right, because I've seen over and over and over again, rights waiver forms that the police are supposed to have not be used, disappear. An officer in a deposition will say, oh, I didn't have any on me. Well, the officer's not going to forget their gun or their badge when they show up to work. So why should they forget a piece of paper, a rights waiver counsel, that can easily be in their briefcase, in their car, in their stack of papers, right? So that's why we go ahead and we take that next step and we actually create it ourselves. Okay. Now, I know Meri talked a little bit about Rape Shield and those different things, but when we're investigating, during this investigation period, don't be afraid to investigate the victim. We must investigate the victim, the alleged victim. There's a huge difference between what we can investigate, what we can actually do, in a deposition and through discovery, and what's admissible in a court of law, right, at a trial or a hearing. So when we talk about Rape Shield, really that's only as far as what's admissible, in court. But you must investigate these alleged victims, and we're talking teachers, friends, disciplinary figures, especially when we're talking about children, but also when we're talking about adults. We want to know coworkers. You have to dive deep into the alleged victim's mind. And the only way to dive deep into their mind, right, to find out possible motives, is to dive deep into their life and know exactly what's going on. Now, a controlled call is a very big part of these investigations, especially when we're talking a late report or when there's no physical evidence. The controlled call is essential in these cases. And most people have no idea what a controlled call is, that it's allowed, or that it can even be admissible against them. So what a controlled call is, usually the alleged victim will be at the police station. She'll be there with the detective in a conference room. She'll have a listening device that's recorded, that's attached to a tape recorder, and she'll call, she'll call your client. She'll call the accused, and it'll start off as a normal call, and I use she and he, but of course it could be any different pronoun, and they're not really trained that much. But it's a quick thing where they get some basic training from the police, and what the police will tell them is, look, make it natural, make it normal. Start off just getting them to talk to you, right? You don't they don't want you to hang up on them, and then you start to confront them with accusations. And a lot of times it's, listen, Bobby, what you did to me was wrong. Okay, I need you to admit it and tell me. I need you to make amends, and all I need to know so I can sleep at night is that you're sorry, and I will never call law enforcement. I don't want to bring this to the police. I just need you to tell me that you acknowledge what you did went too far. Okay, and that's a very typical controlled call. And even we have to tell our clients to look out for it, right? Because a lot of clients will just say, well, I don't know what you're talking about, right? But they won't flat out deny it. We have other clients that will yes somebody to death. Okay, well, if you think I did anything wrong, I apologize, but, right? And that could just be a person yesing somebody to death, trying to get somebody off of the phone without saying, you're a terrible human being, you're lying, I didn't do this, I don't want to talk to you, click, right? So we need to avoid that because those are things that prosecutors and police are still going to use against you. And obviously the worst type is when somebody just flat out says, yes, I absolutely did it, right? So we want to prevent that as well. And that's why you must find out at what stage in the investigation your client's at, and you must let them know about the strong possibility of a controlled call. Now, we're talking about preserving evidence. We want to review and save cell phones. I've had situations where I've literally taken our client's cell phone and we've sent it out to our expert witness to preserve, to download through either Cellbrite software or some of the other softwares, and really will we preserve that right away? And I say, listen, Bobby, you're going to buy a new iPhone, and because you're not going to get an iPhone in prison. So I'm going to take your current iPhone, you're going to buy a new one, we're going to send the current one to your expert, and secure all of this, information, right, and preserve it for later for the case. And you're going to, again, want to make a decision about a potential, subpoena ducis tecum and where that's going to be, if you're going to do that now or not. And really the reason that we talk about the subpoena ducis tecum so much is, at least in Florida, as criminal defense attorneys, we don't have the subpoena powers ourselves, which, different story for a different day, but I think that's kind of crazy that a civil case, you can have full subpoena power for really whatever you want when you're fighting over money. The prosecutors have subpoena power, the law enforcement does, but our criminal defense attorneys don't. We don't have automatic subpoena power. We must go to a judge and request a subpoena. And so if we're going to be doing that, well, we have to tip off the prosecutors to our strategy, to what we want. So, there's always that strategic decision made, and at least if you can preserve the evidence yourself, then you can always make the decision on a subpoena ducis tecum, especially if we're talking about social media and cell phone text messages and all things like that. You can always make that decision later, especially if it's much better if it's your client. Now, if it's something where it's the alleged victim's information and you have 100% conclusive proof from your client that will actually exonerate them, well, then that's something that either you could discuss with the police officers and tell them to go get it, or we can even then go to a judge and and ask for the subpoena ducis tecum. And when you do that, law enforcement is going to look terrible in front of a judge. So with the prosecutors, because you're going to basically tell the judge, hey, this is evidence that we think will exonerate him. They're not even willing to go get it as pursuant to their investigation, right? So that's a strategy on, if the situation merits it, that's a strategy that we've done in the past that has worked very well. The next slide is more about, or goes into depositions, but what I want to do before we talk about depositions, I want to talk a little bit about some of the in-between steps between the client interview and that initial investigation that we had a few slides ago, then deposition. So I'll move back to that original slide right here. Let me see if I can move back for you guys. Oh, actually, I don't need to move back. But basically, what it is, we're talking about a prosecutor's filing decision and an arrest or surrender. And when we have these steps, what I tell our clients is, look, worst case, cops come, kick down your door, find you, they're waiting for you at work, whatever it is, and they just arrest you. And again, that's why we always want to be, we want to make sure the police officers know that we're on the case in a friendly, professional manner, and that everything needs to go with us, right? So we don't want that to happen. We don't want the cops to just bypass us and make an arrest. They don't really want to do it themselves because there's officer safety issues. Above that, well, if the law enforcement officer has made a final decision that they have probable cause to arrest and they're going to make the arrest right away, well, then we at least want to coordinate a surrender. We want to be able to surrender the client on his or her own terms, We want to be there and present always to make sure that there are no, statements given or any violations by the police. We want to make sure that there's a bondsman ready, that we're ready for first appearance court if a client has to go to first appearance court. We've coordinated all of those potential issues where, if the client doesn't have a place to live, we've secured that to make sure that the client has a place to live and survive. And, last thing we want is, especially, really any client to be arrested by surprise, especially at work. So we don't want that. So that's a step above. And then what I tell our clients, the best thing to do is see if we can push off the arrest decision and push it to the prosecutors. So if we can convince the police officer, hey, you may have probable cause, you may not, but regardless of what you do here today, the prosecutor's office is going to have to decide, do they file charges? Do they reduce charges? Do they not file charges and drop it all completely? Because the prosecutors are the ones who decide what charges to file. So because this is not a traffic stop that leads to a cocaine arrest, right? This is a longer investigation. Officer, just send this over to the state attorney's office and let them continue their investigation and give me a chance to talk to them. And so why do I want this? Well, number one, it delays a potential arrest, which is always good, but really it gives me an extra bite at the apple. So we've already been negotiating, and trying to, convince a police officer to dismiss and be done with this case. Well, now we can do it with the attorney, and it's a much different level. It's an attorney to an attorney level instead of an attorney to a police officer. It's not, the attorney's not just looking at this as, hey, do I have probable cause to have him arrested? The attorney's looking at this, do I have a reasonable likelihood of conviction? Am I going to spend my time, effort, right, and energy to prosecute this case if there's no way that half the things are going to be admissible in court, or I don't have any good chance to win? Or maybe the prosecutor might not believe and trust the alleged victim and might not believe it makes sense. The prosecutor's job and the police officer's job are different. Police officer's job is, do I have probable cause to make an arrest? That's it. And so the prosecutors are thinking about so much more. So we've had great success in cases about getting the detectives to not make an arrest and send it right to the prosecutor's office. And then when we can get in lawyer to lawyer, we've had great success in getting cases dismissed. So those, steps 2 and 3, arrest, surrender, or, prosecutor's filing decision are important, very important steps in the process that I definitely, wanted to cover a little bit before we went into the deposition phase. So hopefully that really helps you folks. What we can do now, as far as going into when we're taking depositions on these cases, you must be prepared. This is not a, let me go ahead and take a look at the police report 30 minutes before my deposition because, excuse me, because this is a possession of cocaine case and I've done, handled thousands of possession of cocaine cases, okay? You shouldn't do that anyway in those type of cases, but you especially don't want to do it in these type of cases. Now, you're going to want to be extremely prepared. As I said before, you need to look at the offense at the statute. You need to pull the jury instructions. I love looking at jury instructions. I personally think the jury instructions are easier and better to understand than the actual statutes, and so I love looking at the jury instructions and picking those apart. You're going to want to look at the sentencing statutes because there's a lot of cases where, on the sex crimes, there's so many different enhancement levels and different things that if in a deposition you can, knock some of these things out that maybe a detective or a prosecutor thought they would have, you can knock out years off of a person's life and enhancements just through the depositions. And of course, you're going to want to, beforehand file a statement of particulars if there's a child victim, because you really want these, the information and the allegations to be as limited as possible, so you know exactly what you're going to have to be preparing to defend against. You want to put that onus on the prosecutors, because the prosecutors will just throw everything else at you. There may be a long statement, there may be many different allegations. Well, we need to really, chip away and limit these things as much as possible. And a good analogy that I use is, I'll tell clients, I'll say, well, have you ever been to a fancy wedding or a party and you've seen a beautiful ice sculpture of a swan? Well, it didn't start that way, right? It was originally an ugly block of ice, and somebody chipped and chiseled and maybe took a little Dremel and shaved it and polished it, and over the course of some time, that big ugly block of ice became a beautiful swan. And in cases, especially sex cases, it's the same exact thing. If you can't blow the case out in the investigation or the pre-filing stage, well, then we're in for a battle, and it's a slow chip, a slow chip, a slow chip. So part of that statement of particulars is just chipping away and really trying to hone in on what the actual allegations are and what the prosecutor's trying, or is going to be planning on trying to prove against your client. Through the discovery, you have to know that discovery backwards and forwards, not just police reports, but all witness statements. You want them audios, videos. Don't rely on transcripts. Transcripts are often wrong. You're going to want those audios and videos. If their medical exams have been done, you need that. You need to get CPT's file as well, and you need to have, like we talked about earlier in the investigation stage, records of the victim. That could be phone records, employment records, school records, and whatever evidence that you've preserved yourself. And as we talked about school, right, especially when we're talking about children, we want to know who reported it. Was it a teacher? Was it a parent? Did they tell any of their friends? Why did they tell their friends if they did? What kind of social groups are they in? There's different social groups for a 6-year-old than a 10-year-old versus a 14-year-old. Have there been any grades or disciplinary issues? If so, what are they? When did they start? You must build that timeline. And of course, here in Florida, any evidence that we get, if we don't plan on using it, well, that stays between us. So we're not under any of those discovery obligations where we have to give the prosecutors things if it actually is bad for our client. So we're going to want to get that. More often than not, it actually helps us, and it helps our case. And if we have adult, alleged victims, then we're talking about their work environment. Not just their current work, their former place of work. What's their work history? Has there been a long history of behavior issues, discipline issues, erratic behavior? We like to go wide and then narrow it down. Well, specifically at the timeline, right? We're looking for things, had there been any changes? And if there hadn't been any changes, right, but this person continually had, right, bad behavior, well, then that can be really good, because unfortunately for us, the detectives and the prosecutors, they'll be focused on the immediate timeline, the here and now, and they'll say, well, her job performance suffered. Okay, but did they know that for 10 years her job performance was bad, and he or she was fired from 3 other places prior to this? So that's important, that prosecutors and police will never know. They're never going to bother to get. Did they tell any coworkers? Did they tell any family? And as defense attorneys, we know the more times you tell a story, little things change, right? Well, it's their burden and their responsibility to make sure that it's accurate. So if little things change, well, then big things can change too. And that attacks and really, reduces and lowers the alleged victim's credibility. And that's what we're looking for. That's another big part of what we're looking for in these cases. Now, we're going to want to make sure that we're talking about Sexual Assault Treatment Center now, the SATC, on these cases when you have these. So these will be involved in cases that are usually not late reports. But there'll be a video statement of the child. We need to review that statement backwards and forwards. You need to know everything about that statement. And we keep going back to timelines. Well, investigation timelines are very important as well. When we're doing, investigation timelines, when the police or the Sexual Assault Treatment Center, they're doing that, there's such a high suggestibility, even more so than in photo lineups. And, over the years, the process and procedure for photo lineups have changed quite a bit because there's been study after study that's shown that they're highly suggestive. Well, the same for this. And we've seen many cases where the officers involved, they will spend 2 hours speaking with the alleged victim. They'll spend another hour speaking with the alleged victims, if it's a minor, the parents or the complaining parent. And then they'll go on video, and we're talking about a 10 to 20 minute, videotaped statement. And we have no idea what was discussed prior to for an hour or two, right? So, they're trained in the suggestibility of children. And you don't want these people to know much about the case, kind of like, the same way photo lineups. Most departments have changed so that way the officer who's conducting a photo lineup knows nothing about the case, is not the investigating officer at all, and there's no body language issues, there's no suggestibility issues. Well, it's the same in this. You want to make sure that they don't know much at all and that they're asking open-ended questions. They're not asking leading questions. Unfortunately, they get it wrong all the time. And, we as defense attorneys can never substitute, their word for the truth or just trust them. They are not to be trusted, and that's that's why we must investigate over and over and over again, and really don't be afraid of being aggressive with them, because we have clients to represent. So we really need to go at them, and be hard on them. And, it's the same, whether it's a sexual assault treatment center and a minor child or the police officers. These police officers, they're trained, but they're not experts. What does training even mean? They went to a 40-hour course. Okay, so if you went to a 40-hour course, that's 5 days of your life. Okay, you completed 120 course hours. Fine, that's 3 weeks of your life. Just because you've been a sex crimes detective for 10 or 20 years doesn't mean you know what you're doing, and it doesn't mean you're doing it the right way, okay? So we never, ever just trust what they're doing. And you're really going to want to pull policies and procedures of law enforcement. You're going to want to have those documents and compare their policies and procedures for how they interview, whether it's a sexual, assault victim, alleged victim, or a child minor alleged victim. How they're supposed to do the interviews. You're going to want to look at their internal policies and procedures, which are public records, and compare that to what you're seeing on video. And you're going to want to be prepared to question them about any pre-interviews, post-interviews, all of those things, because as we know, children want to please authority figures. Children are highly suggestible. I'll tell you guys a quick story, and a lot of this, I have a 3-year-old child and a 3-year-old son, and a lot of these things you just don't know until you're a parent, right? So he's 3, and we have a little magnet, like little locks on our kitchen cabinets, and they're opened by a magnet. So what we would do, my wife and I, we would take the magnet, we would put it over the lock, and it would open. right? And that was our child protection lock. So what happened was we dropped the little circular thing that had a casing that had a magnet in it, right, to open the lock. The casing opened up on the floor. We could not find the magnet, and my son Chase was there. And we looked everywhere. We could not find the magnet. So my wife and I got a little nervous. We got scared. We said, did our son eat the magnet, right? If he did, that's very serious. So we asked him, and he said no, but, he's 3, right? It's not like he's 10. He's 3 years old. So we said, better be safe than sorry. Let's go to the hospital. So what did we do? We took him to the hospital. We were in the ER. We're in the pediatric ER. We're there. The doctor said, Chase, did you eat a magnet? He goes, yes. She goes, okay, no problem. Let's take him for an x-ray. Let's see. So they did, right? My wife and I are trying to hold it all together, make sure everything's going to be okay. And guess what the x-ray showed? There's no magnet at all. Now that doctor didn't really, that doctor could have said, Chase, what happened? Now, technically it wasn't leading. It was a yes or no. The answer to an adult was not suggested. But to our 3-year-old son, when a doctor asked him if he ate a magnet, he said yes. And he clearly didn't. And it's not that, he's a liar or his intentions are to lie. It's just who knows what was going on through my 3-year-old son's mind, right? But going through that process, I turned to my wife and I started talking and thinking, I'm like, and seeing back, well, these things, that's just one example that in my life that now can be used for criminal cases and how children, answer questions. So hopefully that resonates with you folks on this CLE presentation. Well, if we do have, for victim and child victim, right? A child victim, needs to be videotaped for the deposition, okay? And you want to make the child comfortable, but you got to know everything about them. You need to know more about them than their parents, than their loved ones. You really need to investigate them because of, what's on the line. Your client's life usually, right? Their future, their freedom. The only people present should be, you, court reporter, state attorney, and the victim advocate. Do not allow anybody else to be in that deposition room. That deposition room is your sacred place. Sure, there's accommodations being made. You want people to be comfortable because as they're comfortable, they will generally give you more information. But you're in charge of that deposition. That's your sacred place. And you want to ask questions. Like start off with some easy ones, but then you want to get into friends, school, grades, clubs. A lot of times when we're dealing with children, we have to kind of get back into our minds when we were children. And so there's a lot of self-reflection about, hey, when I was a teenager or a preteen, my parents didn't know a lot of things that was going on in my life with my friends that we talked about, that we were doing. So you have to be able to get deep with especially with child victims, to really get them to open up and let them know, open up, because there's things that they probably hid from their parents or maybe even hid from the police. And really you want to be able to ask questions that can be tested against other evidence, right? So what does that mean? We're talking timeline. We're talking location. If it's, a molestation allegation, well, how many times, right? Where were they? And don't be afraid to make it slow, boring, monotonous, but detailed. It has to be detailed because this is your biggest chance to really peel things back prior to a trial. And the point of these depositions, yes, it's it's an additional way to fact find, okay, tremendously, but it's also an additional way to really lay out inconsistencies, not necessarily your theory of the case, but lay out real inconsistencies and really set up set your case up for trial, and you must do both. Okay, and so we want to know about, well, where'd the evidence go? If there was any evidence, why wasn't it preserved? Anything we can also do to attack law enforcement's credibility. Did they not instruct, an alleged victim, that was timely reported to save and secure clothing, right, and other evidence? So all of those things can really help your case, and you want to, get into the deposition. As we talked about being slow and monotonous, it can be awkward. But slow and monotonous, right, is kind of the tortoise versus the hare. That's what wins cases. That's what it is, in order to be, most effective for your client. Okay, and we put up Rule 3.220 in Florida for the Discovery Florida Rule of Criminal Procedure, talking about deposition of sensitive witnesses. So you folks can read that here, but it's basically under the age of 18, or a fragile emotional strength, if there's an intellectual disability, things like that. But that's the statute for that. But yeah, I mean, these are we're all human beings. The last thing I think any of us really enjoy doing is having a 3-hour or really long, detailed deposition with an alleged victim or a minor alleged victim, going in detail about sex crimes. But it is what it is, and we're here to be advocates for our clients and really, push forth and get the best representation, because a lot of these cases that we've seen have been false allegations, or have been situations where, things just don't add up, right? Or have been situations where the criminal justice system is being manipulated for another issue, such as, child custody, family law issues. We've seen that, and what I've seen especially is prosecutors do not like that at all when they feel they're being manipulated. So that's always, important as well to really, know. One of the last things that I'm going to talk about is on a child victim, a motion to perpetuate testimony. And these are kind of awkward. If you've ever done one, it's very awkward, it's weird, but the more you do them, the better you get at them. And it will look and feel like a trial. It will be played for the jury at trial in a way that they usually, they do stuff like this a lot more in civil. But you have to object, if for the grounds of the motion, and make sure, and really try to prevent that if possible. Okay, because, there's a lot of times where the prosecutors will try to do a motion to perpetuate testimony, and they don't need to do it, right? And so if you can prevent that from even happening, well, that's your best bet, okay? That's your absolute best bet, is to prevent it from happening. And so, we always like to say here, you only get so many yeah buts, and it's better to not have to say yeah but. So in this context, it's better to strike, their motion to perpetuate testimony or have the judge deny it than to have to go through this whole thing and process, because it can be awkward. It never is the same in front of a jury than live testimony and feeling the energy during a cross-examination. Feeling, seeing full body language, being in the moment, right? For example, our Zoom, CLE right here, this is great, but imagine being in a room with me and my team lecturing on this in person, with a packed room where you can actually, feel the energy and see things live, and, really use all of your senses in three dimensions, rather than just seeing a presentation over Zoom that, yes, you can see my body language, but you still can't feel the energy of the room and of all the parties. So that's very important as well. Something that everybody should, be prepared for, especially really primarily on child, on child alleged victim issues with this. And and with that, I'm done with my portion. Our firm, again, here's our information. We help good things when bad people, or good people when bad things happen, so they can achieve their best future. And if anybody wants to keep in touch, we love meeting people. We love talking. We love educating. We love helping. We really believe that we're community and relationship builders first, who just happen to be really good criminal defense attorneys. So that's why we love, presenting these and doing it. I don't see any questions right now. If there's any questions or anybody wants to, has anything at all, I would love to answer them.
Welcome back, everybody. My name is Susan Lawson. I'm one of the partners here at the Rossen Law Firm. Thank you for joining us. So today I am going to talk about voir dire and trial. And I know you heard from my partners, Meri and then Adam, and they talked about a lot of the stuff that would happen pre-trial. We're going to get into today the stuff that's going to happen once you're set for trial. So I'm going to get into, speak to you guys today about getting the jury on your side from the start of the case and cross-examining the victim. So again, this is me, Susan Lawson. I'm a board-certified criminal trial attorney. I've spent most of my career practicing in South Florida, particularly in Broward County. However, I have also practiced in the state of Maryland and So the first thing I wanted to talk to you all about is voir dire. So the questionnaire. A lot of times it depends on, in Florida, I know, what jurisdiction you're in, what circuit you're in, if the judge you're in front of would allow you to submit to the prospective panel questions. So we've done this here, and it's really on a case-by-case basis, on a judge-by-judge basis. In a lot of our capital cases, which, as you know, sex crimes can be capital sexual battery cases, it's a good idea. I recommend that ahead of time you file motions asking the judge to allow the prospective panel to fill out a questionnaire. And these are just some questions that you could put. And, a lot of times we'll go back and forth. We'll have a hearing, a pretrial hearing with the judge and the state, and we'll put together a questionnaire for the prospective panel. And the reason why it's so helpful to do that is because you get to know a lot about the prospective panel before you even get up and speak to them. So some of the questions that I've used before I put together on these slides, you could ask, do you know what is considered sexual abuse or sexual assault? Have you been a victim of sexual abuse or violence? A lot of times that is a question that we do get to know ahead of time. When, how old were you? Was it in Florida, the US? Where did this occur? Was the matter reported to authorities? By whom? If not reported, was that your decision? Was there a trial or was a court involved? How was the matter concluded? Did you give a statement or more than one statement about the matter and to whom? These are very specific. I have not had great success in getting approved by the judge all these detailed questions. Are normally more general, but certainly I would recommend trying to allow the judge to grant you permission to ask these questions to the prospective panel ahead of time. Some more questions that you could submit as proposed questions for the panel is, if this matter was handled by law enforcement and went to court, how do you feel about the way the matter was handled? Is this event something that you would think would be influenced by if selected as a juror in this case, or is this something you believe you can set aside? Again, in jury selection, what are we looking for? We're looking for jurors that can be fair and impartial in this case. For either answer, how can you be sure? Has anyone close to you been a victim of sexual abuse or violence? That's very important. How do you know? regardless of the source of your understanding of what happened to your friend, loved one, what you learned happened to be something that would negatively impact your ability, again, be fair and impartial during the case. How do you or someone close to you, has they ever been accused of sexual violence? How do you feel about this? Do you believe that this will negatively impact your ability to be fair and impartial? So getting those questions answered ahead of time is really helpful, and I recommend you doing that. So, voir dire. So you always have to start out by addressing the elephant in the room. And I put this picture, and I realized when I put this picture, it's more of a mammoth, not really an elephant, but this was taken. I don't know if any of you have been to the La Brea Tar Pits Museum in Los Angeles, but that's where this picture was taken from. So when you're addressing the elephant in the room, how do you do that? So you start out. You heard, ladies and gentlemen, that Mr. John Doe is charged with sexual battery of a child. And you let them know, you let the jury, the panel know that we're going to talk a lot about things that are very uncomfortable. As you know, voir dire is the most important part in the trial process, because the individuals that you end up on your panel are going to be deciding the ultimately guilty or not guilty in this case. And in particular in sex cases, it's very, very important that you address right away the charge. Recognize that because you want to build a relationship with the panel, that that this is uncomfortable for most people to talk about. And then you get into, after you say the charge, address the issue as far as most people don't feel comfortable talking about those words, anal, sex. Those are uncomfortable things for people to want to talk about and their experiences, but you have to let them know that you recognize that it's uncomfortable. You recognize that each and every one of those individuals walk into that the jury room and walk into the courtroom, and you don't expect them to leave their personal experiences, at the door. That's not realistic. So you need to find out. It's information gathering. Adam was talking about in the pre-investigation, getting as much information as possible. That's what we wanted. That's the goal in voir dire, that we want to get as much information as possible about these prospective members of the jury, because we don't know much about them. Maybe perhaps if you get what I was just talking about, if you get granted the questionnaire and know a little bit, but we want to really dig deep. And the reason why we want to dig deep, because we need to know if these are people, obviously, we want sitting on our panel. A lot of times in these sex cases in particular, people will say, and you'll get them to say, hopefully, this isn't the case for me. I would rather be sitting in a murder case than sitting on a sex case. But those are things you need to know. So after you address the charge and that it's uncomfortable, the next thing I always ask is just a general question. Does anyone here, just by hearing that this is a sexual battery of a child, this is a lewd and lascivious molestation, just by hearing the nature of the charge, does anyone feel they may not be fair and impartial? And normally in these type of cases, you get a lot of hands raised, right? And then it's important that you address, go take your time, go slow, talk to each one of these prospective members of the panel and find out, do they feel uncomfortable just by hearing the nature of the charge? And in these type of cases, you're going to get a lot of cause challenges. And as we know, a lot of cause challenges is unlimited, the number. I've had doing many of these cases, I've had to, because I've been granted so many cause challenges, had to bust the panel, wasn't able to get a panel, but that's okay. That's good. We want to get those cause challenges. And I cited a case here, which you can see, Alt v. State, that says the Florida Supreme Court has emphasized that a juror must be excused for cause if any reasonable doubt exists as to whether the juror possesses an impartial state of mind. Another thing that's really important to talk about the panel, sympathy, right? And especially in these sex cases. Again, recognize and sympathize the sensitive nature of the charge, but make sure each juror knows, and when, at the end, when the judge is giving the rules for deliberation, this is in the rules for deliberation, but make sure each juror knows that this case must not be decided for or against anyone because you feel sorry for anyone or because you are angry at anyone. And then follow up. Does everyone understand that? Can everybody follow the law? And, a lot of times you'll see people who, don't want to speak in front of their new crowd of best friends. So they're quiet. They're just sitting there. So at the same time, it's always, we here at the Rossen Law Firm, if we're going to trial, especially on all our cases, but especially these type of cases, we always have at least 2 of us from the firm sitting on the trial. And so if I'm focused on, this part of the panel, I'll have my partner, watching the body language. The body language can tell a lot, especially when the charge is read. So if people aren't being forthcoming on the panel, we're always watching for those eager beavers, we call them, head shaking, body language, because words obviously can tell you a lot, but so can someone's body language and how they're presenting themselves. And you can't be afraid to, if they're not speaking, and I recommend you need to talk to each one of these people on your prospective panel. And, it's okay to say, hey, Meri, it looks like you may be a little uncomfortable. Is there anything that, you've been thinking about that, this is my only opportunity to speak to you, that's bothering you? Are you okay with the charge? Can you follow the law that you can't, you may hear from a young child, and you can't we can't ask you to put your emotions aside and again leave them at the front door, but do you understand that this case can't be decided for someone because you feel sorry for them? Are you able to follow that law? So again, speaking to the prospective panel, you're going to get a lot of parents, a lot of grandparents. So speak directly to parents, especially those that have children or grandchildren that are the same age. You have a sex case where the alleged victim is 8 years old, right? The last thing you want is to have someone sitting on your panel and then to later learn after it's too late that, they had it have the same age child. They have an 8-year-old child. The alleged victim's 8 years old, and the victim reminds them of their own child. That can become a serious issue. So, and by the questions you ask to figure this out is, you have to harp on, can each one of you look at Mr. John right now and say he is innocent? And if you can't, that's okay, but we need to know. I always, when I get up there to speak to the panel, I always tell them, the more you talk, the quicker I'll be, but you really, really have to take your time and methodically talk to these individuals, find out as much information as you can. But I do say that, and sometimes that helps them start talking more. So, ask them, can you go home every night and have dinner with your kids? Address that, this is a case. These cases normally take a week, 2 weeks. I've been in one that's been, much longer, a month. Is that okay? Are you going to be able to focus on and give this case your undivided attention? Or are you going to be thinking about, picking up your kid at school and all the other responsibilities you have? You understand that you can't go, if you are selected on this panel, that you can't go home at night and talk to about this case with your partner. I'm sure you're going to want to talk, but the law says you can't. Are you going to be able to follow that? Can you go home every night and still maintain that Mr. John is an innocent person until proven guilty? And when I'm reading when the charges are read and I'm speaking, and I always ask the prospective panel, how many of you walked in here, saw Mr. John sitting next to me, and thought, what did he do, right? That's a natural reaction. But that's not what you should be doing here. It's not what did he do, it's what can the state prove? What if you think he did do it, but the state has not overcome that high burden, that burden of each and every element beyond a reasonable doubt? So can you still find him not guilty and go home to your children after? And again, you have to let them know, if you can't, it's okay. We recognize this is very difficult. So it's important to get the panel to obviously like you and to get as much information from them. So this picture makes me laugh, that the little girl taking cookies out of the cookie jar. But you have to speak to each juror individually and see, because kids lie, right? So you have to talk to them and ask them, do you think a child can make up a story about being molested or raped? And some people will say no, that they don't think a child can make that up, that if a child comes in, and in a lot of these sex cases, there's no corroboration, the state just has the child. There's no witnesses. We're going to get into it. Sometimes there's DNA, but sometimes there's not. So a lot of times they just have the child, and that's, you want to know on this prospective panel, do you believe that a child can make up a story specifically about being molested? And again, this is what I was talking about just a few minutes ago. For parents, make sure you follow up with, will you look at the victim in this case testifying? And is there a chance that maybe, he or she will remind you of your own child? And then I added these cases, the case law, that, it's very important to remember that you are allowed to voir dire on your specific defense. So, and it's an error, the judge has to allow you, and I cited these the known cases of Lovato and Mosley, that it's an error for the judge to not allow you to do that. So, and when you're picking a panel, make sure you, when you're going through, make sure you make your proper objections, make sure you renew your objections, make sure at the end, you ask for more strikes and then refuse to accept the panel for appellate purposes. So here we're talking about DNA. And again, during voir dire, this is very, very important to address, especially if you know, and you'll know through discovery, if DNA is an issue in your case. So it's very important to let the panel know that it is not infallible, and it is interpretations made by someone who will testify, and that the panel will have to judge their credibility. A lot of times, and I know this is kind of hard to see, but I put this is one of a case that we've had. You get in discovery, you get a DNA report, and right, it's comparing, where they got someone's DNA, and then the results. And a lot of times, an expert will come in, right, and say, 1 in 1 million Mr. John Doe's DNA. So talking about the credibility of DNA when you're selecting a jury, talking to them about that is extremely important. And how how do we talk to a panel about someone's credibility? Some of the questions I ask when talking about someone's credibility is, do you believe that people who are called by the state and take the witness stand always tell the truth? Now, and then I'll address defendant testifying or not testifying. Now, if John Doe does testify, will you disbelieve him simply because he is charged with this crime? And I let them know that they're the sole judge of credibility and that they can believe all, some, or none. And then I'll go into, some of the things ways you can judge credibility. Did the witness seem to have an accurate memory? Sometimes I'll get into how many lies does it take for you not to trust someone. But it is very important to address credibility, especially when you have DNA. I recommend doing it all the time, but especially when you have DNA, because you do not want this expert witness or coming in and saying these numbers and then they turn their ears off already. So Meri, I know she started the presentation and she spent a lot of time speaking about Williams Rule, and a lot of time can be spent, probably a whole presentation on Williams Rule. So Williams Rule is similar fact evidence of other crimes, but it's so important in voir dire to talk about Williams Rule. So prior to trial, as Meri talked about, the state files their notice of intent, you file your objection, you have a hearing. And, it's very hard to exclude a lot of times the Williams Rule evidence. So if you'll know ahead of time, hopefully ahead of time, if the Williams Rule evidence is coming into your case, because one time we had the situation where the judge tried to say, oh, no, after we pick the jury, then we'll have the Williams Rule hearing. No, you need the Williams Rule hearing held prior to trial, obviously, so you can properly prepare, right? So you need to address with the prospective panel because they're going to be confused, and you have to tell them this is an odd issue that they will hear from witnesses not listed in this case. Say what? And if you believe that a witness is telling you the truth about that case, but you think the victim in this case is not telling the truth, you need to find out. Can you still find him not guilty? Meaning they believe the person, the victim in the other case, but they don't believe the victim in this case. They must find your client not guilty, which is very hard because a lot of times if that happens, they'll think, oh, well, I believe her, so I'm going to find her guilty, even though that we're not talking about the same case. So that's and spend time going through this. It's very, very important. And instruct them, let them know, even if you believe the witness was molested, the witness, you must find not guilty. And I would go through, ask each and every member of that prospective panel, can they follow that law? And if there's any hesitation, follow up. I see you hesitated. Can you, ask them to elaborate on that hesitation. But again, in sex cases, Williams Rule evidence explaining to them that you may hear another witness come in that's unrelated to this case, you need to explain that and address that. And even if they believe that witness, but they don't believe the victim in this case, you have to reinforce that they must find your client not guilty. So we've been, not all sex cases are obviously dealing with children, but we've been focusing on that really today. So it's important to recognize the law as far as child witnesses, that the competence of a child witness is based on intelligence, not age, and whether the child possesses a sense of obligation to tell the truth. So as we all know, I have a 6-year-old child and a 9-year-old child. My 6-year-old child acts like he's he's my 9-year-old's age. So again, it's not the age that matters. It's based on the intelligence and whether and this is something that has to be determined prior. And I know Meri talked about child hearsay, but that it's the intelligence, not the age. So when ruling on a child's competency to testify, the trial court should consider whether the child is capable of observing and recollecting facts, and whether the child is capable of narrating those facts to the court or to a jury, and whether the child has a moral sense of the obligation to tell the truth. And so again, this is all stuff that prior to a child testifying, obviously you need to address in jury selection the child testifying, but the competence of a child needs to be addressed prior to trial. And in making the competency determination, the child may base its determination on its own examination of the child or an attorney's examination of the child. The court may also consider expert testimony and reports in fulfilling its duty to determine competency, and I cited a case there. And this is very important. Failure to adequately to conduct a competency evaluation on a child victim can lead to reversible error. In Florida, Fry remains the standard, not Daubert. Okay, so there is so much I could cover as far as voir dire. It's so important. It's so critical that, again, you reiterate, you get them to like you, you sympathize with them, that this is uncomfortable, and you try to get as much information from each prospective juror for those cause challenges. So once you have that panel, once you're done with doing the strikes and you have the panel and they're seated, the next topic I'm going to get into is cross-examination of a child victim. And I have this picture here of this little girl holding this teddy bear. And this has happened to me before in a case where a little girl got on the witness stand, brought her little teddy bear and sat there just like that, holding the bear. Had children come in with dogs. You need to try to, address that before the child comes in holding the teddy bear, because how prejudicial is that for you, right? You see that, you don't need to hear anything else. So make sure when a child is testifying in trial, they don't come to court with a teddy bear. A lot of times the victim advocates give them these teddy bears or something, that they don't have that while they're testifying. So, cross-examination of a child victim. So this is really more fact-specific, so you have to use your own judgment when preparing to cross-examine a victim ahead of time. So it's really important to, if there's a delay in reporting or if it was reported right away. So, and also the age of the child. So if there is a delay in reporting and the child is now older, you can go harder on them than if the last slide like that. You can question them in cross-examination. Why didn't you tell anyone this before? And then you methodically go through in your questioning, all the opportunities they had to report this before. You report this to anyone at school. Did you report this to your guidance counselor at school, to your principal, to your assistant principal, anybody at school? A lot of times these children have gone through custody hearings. Did this ever come out? Did you ever tell anybody in a custody hearing? Did you report this to any of your friends? And if the answer is no, then why now are you just choosing to report this? So it's very important that you go through in detail, and you'll know that obviously when preparing your case, the answers to these questions ahead of time, through the discovery process and taking the depositions of the child, which Adam talked about, which is very important, but you'll know the answers. And if they didn't report these, and it's an older child, I encourage you to go hard on them as to why they didn't report it and why now are they just reporting it. So if they didn't report, but mom found out, right? How did mom find out? So I had a case where mom found presents from a client, right? And cell phone, chips, the client had bought her kid different things. You know, it's when you're cross-examining the child, suggests that the child didn't want to get into trouble because maybe someone else gave it to them. You know, the mom confronts the child and the child's protecting somebody and blames your client, right? Also, a lot of times, you know, parents find out that their child had sex and confronts their child. And, you know, same thing, the child doesn't want to get whoever they had sex with in trouble. So what do? They conveniently blame your client. And again, do not be afraid to impeach. So impeachment is so big because obviously that's how, you know, when the jurors go back and to weigh the evidence, that's one of the big things in weighing the evidence is impeachment. So don't be afraid just because the person on the stand is a child to impeach them, right? And hopefully by the time you're getting to trial and you're cross-examining the child, you know, you have the prior statements, you have what the statement that they originally gave at the sexual assault treatment center. Then you took the deposition of the child. So you have 2 prior statements of the child. And then now they're taking the stand. You know, make sure you have, I always have my, my prior statements tabbed up, highlighted, written the pages. So, you know, but don't be afraid to go back and impeach if they're saying something different. And most of the time they are saying something different, right? Because like I always say, it's easy to remember the truth, but hard to remember lies. And you know, the reality is in a lot of these sex cases, the child or the victim is lying. So this is a slide just on impeachment. You know, again, a party may attack or support the credibility of a witness, a victim, or the accused by evidence in the form of reputation evidence, except that the evidence may refer only to character relating to truthfulness. Evidence of truthful character is admissible only after the character of the witness for truthfulness has been attacked by reputation evidence, and that's under Florida Statute 90.0609. However, any witness may have their truthfulness impeached for being convicted of a felony or dishonesty or a false statement. That's under 90.610. Reputation evidence relating to a victim's prior sexual conduct or evidence presented for the purposes of showing that manner of dress of the victim at the time of the offense and site of the sexual battery shall not be admitted into evidence in the sexual battery case. Further, specific instances of prior consensual sexual activity between the victim and any person other than the offender also shall not be admitted into evidence in a sexual battery case, except for specific enumerated reasons. After that, that's something you would have to deal with in camera prior. So we were just discussing if a child either, you know, does not report or delayed reporting. So what do you do, and if the child was older, but so what do you do if a child reported right away or is very young? So, right, you have to know what you're dealing with here. So in this situation, instead of going harsh, you need to go easy, because no juror is going to like you if you have that little girl sitting on the stand and you're going harsh on her. So go easy. And normally in this situation, their testimony is usually pretty short, right? Because the state will rely on the child hearsay, which we already discussed, or other evidence. So what do? You focus on your specific defense. So in a recent trial, we focused on the specific timeline the child gave to police because it didn't match up when the sex had to occur for pregnancy. So this is all stuff you obviously you're going to learn prior to trial, but in cross-examining the child, it's very important to, that's how you can do a great cross on a young child or a child that reported right away. Oh yeah, sure, the state focuses you reported right away, but this timeline doesn't add up, and go through the timeline that you created, right? So ask them go into the attention they got as a result of this accusation. Ask them who they've spoken to about this case. Ask them, did your mom give you anything? Did your mom take you to Disney World? It all goes to, the truthfulness of the child. And as we know, as I've already stated, kids lie. So a lot of, hopefully you get, by picking the jury, you get people on your panel that recognize kids lie and recognize through your great voir dire, recognize that not only do kids lie in general, but kids do lie about being sexually molested or raped. So the fact that you have these people hopefully on your jury, so that make sure you ask this child who reported right away or who is very young, ask them about the attention they got as a result of this accusation. So, because many times children make things up because, as we know, they want attention, right? So, they say, they think it's going to be helpful. They say something to their mom, not realizing that, that what they tell their mom or dad is then going to be reported to the police. And then it turns into this whole investigation, and they feel like that they have to stick with their lie. A lot of times, once policing get involved, the child feels like it is too late to take it back. So cross-examination, of a child victim, I highly recommend, obviously, that it's really important to recognize if it was reported, when it was reported, the child's age, if they're very young, if they're older, and not only frame your questions, but frame your plan of attack based on that. And as far as, you can go into, don't be afraid just because you're cross-examining a young child, don't be afraid to get into the details and to really cross-examine them. I recommend, obviously, you do cross-examine them. And, all these ways are cross-examination. Again, a lot of times, as I said, in these cases, there is no corroboration. So the state thinks, that by calling the alleged victim, who is a child, that that's all they need. And a lot of times, it obviously can be all they need, but how do you win your case? How do you win these cases, these difficult cases? Cross-examining that child is key. And, once you're done cross-examining the victim in this case, my opinion, second most important part of a trial, my favorite between voir dire and I love closing. So, it's great too when you have your partner sitting with you, taking notes. I love when you get the opportunity to, break for the day and prepare your closing for the next day, because everything, the impeachment of that child, every single time you impeach that child, the amount of times they said, no, I didn't report it to anyone at school. No, I didn't report it to any one of my friends. All of that stuff. So all of that great information that you get from cross-examining the child, you got to tie that all into your closing argument. And And, I really recommend be detailed as possible in your closing argument. But all this great information that you get through the questioning and your cross-examination of the child, you tie that and you hammer it home, and you bring that all into your closing. So as far as your closing, so right, we talked about if you're dealing with a very young child at closing, you don't want to vilify the child, but you can say, I don't know why they made it up. Maybe they made it up for attention. Maybe someone put it in their head, but it is not our job to tell you the reason they told this story, right? This fabrication. And then, we know it can't be true because of X, Y, and Z. We know it can't be true because of the timeline you presented in your cross-examination. And in your closing, again, be very, very detailed. Something I always love to say in my closing arguments are, ladies and gentlemen, you go through the different ways reasonable doubt can arise, the evidence, conflicts of the evidence, or the lack of evidence, right? So obviously, reasonable doubt is a huge thing to address in closing argument. A lot of times, I think it's really, really beneficial to read the reasonable doubt jury instruction, because it's great when they not only hear it from you, then they hear it from the judge, and then they get the packet to bring back with them. But I love to say, ladies and gentlemen, at the end of this case, you will have more questions than answers. And more questions than answers, that equals reasonable doubt. And another thing I like to add, obviously tie the facts and the great things you got out of your cross-examination into your closing, but I love to say, probably guilty, not enough. Possibly guilty, not enough, and really hammer that reasonable doubt, because when you're picking the jury, you're going to tell them, we all know, you let them know that when you're picking the jury, ladies and gentlemen, if you were to go back in the jury room right now, what would your verdict have to be? And at the time, have to be not guilty, because you haven't heard any evidence and he's presumed innocent. So make sure that, especially in these sex cases, and especially in dealing with sex cases that are involving young children. Again, you don't want to turn off the panel by vilifying the child, but you can again say, it's not our burden to prove to you, why this child made it up. There's a variety of reasons why the child could made it up. It's not our job to tell you that, the state hasn't met their burden of proving beyond a reasonable doubt that this happened, and the reason why it can't be true. And really, I encourage, when you're doing your closing argument, obviously be passionate, make eye contact with each and every member of the prospective panel. And through your great, pretrial motions, dealing with, the Williams rule, dealing with addressing that in your jury selection, addressing everything we've spoken about, doing that amazing cross-examination, and then hammering it home in closing, I feel confident that, these cases, although they are hard, they are winnable, and you will get the jury on your side. So I don't see any questions, but I wanted to thank you all. This is my contact information. I would love, we've done many of these type of cases. If you need help in preparing cases for trial, questions for voir dire, questions for cross-examination, just anything related to a trial, this is my information. Feel free to reach out, and thank you very much.
Hey everybody, hope you enjoyed your break. This is going to be the last substantive section of our CLE here today on sex crimes. I'll be focusing myself on federal sex crimes, and then at the end of the presentation today, we are going to have a question and answer session, kind of like a round table, with all of the attorneys at the firm who have presented to you today, just to kind of bounce ideas around, talk about some war stories and some great results we've gotten for our clients in this realm of sex crimes, both state and federal. And we think it's going to be a great experience, all said and done. So just a bit about myself. I'm one of the partners at the Rossen Law Firm. Again, my name is David Tarras. I'm the head of our federal criminal defense practice here at the firm. Our firm has federal cases throughout the country. Primary area of focus is the Southern District of Florida, which covers everything from Key West to Fort Pierce. The major areas, the major hubs, so to speak, of the Southern District of Florida would be Broward County, Fort Lauderdale office, West Palm Beach, and the Miami-Dade. And we practice in all those areas. Our firm is based in Palm Beach County and based in Fort Lauderdale, but we kind of hate it, and we love what we do with this. So being that I'm the head of the federal criminal defense practice here at the firm, what I'm going to be speaking to you about are federal sex crimes. Now, a lot of what you have already heard from my amazing partners that they have presented to you is still very much applicable to the federal system as far as trial, the way we fight cases, the initial client interviews, the investigations, motions, the law, because a lot of the law in state court and certainly, of course, in federal, and in state court is structured off of the federal rules of criminal procedure and federal rules of evidence. But what really is going to be my focus for the purpose of my portion of the CLE are the nuances of federal court when it comes to sex crimes, and kind of the nuances of federal court in general, because they are one and the same in a lot of ways. Again, a lot of federal is like state, but a lot of it is different. And primary differences that really don't relate specifically to sex crimes are the discovery tools, the timetables, the agencies and law enforcement agencies that are investigating federal sex crimes, as opposed to a local county, state law enforcement or sheriff's office. Here in federal sex crimes, and the firm is dealing very often with the FBI, with Homeland Security, Secret Service, the Postal Service, especially in situations where, as it relates to federal sex crimes, that certain unlawful material, such as child pornography, which we'll be discussing, or other obscene material, is transported and mailed across state lines, and also individuals who are using highways and interstate methods to travel across state lines is how we start getting into the realm of federal. Of course, across the board between federal and state, we're talking about, when a federal sex case, some of these amazing tools that my partners had discussed with everybody already don't apply in federal, and that makes it very challenging. For one, we don't get depositions in federal. The discovery tools that we have in federal, we have the motions, we have the ability to challenge evidence. Biggest difficulty being, of course, that we don't have depositions in order to gain a lot of our best ammunition in filing these motions and digging into these cases. So we have to adapt and find other ways. It's extremely rewarding, federal sex crimes, but it's also very difficult, and you have to really know what you're getting into. There's lots of different kinds of federal sex crimes, spanning vast different amounts of statutes. The ones that we're going to be focusing on today, and a lot of this with these charges will apply to state court as well, and how you go about your state practice in defending sex crimes. But our major focus is going to be child pornography, child sexual exploitation, and the use of materials resulting or being created or distributed from child sexual exploitation, and that is essentially child pornography. There are a lot of different statutes within the federal system that cover child pornography. We're going to be taking it from a more broad perspective. I could focus for an hour each session on each one, but one of the reasons why I think it's going to be most beneficial in the sense of child pornography and to focus on that in the federal system is because that aspect of it is cyber sex crime, but also child pornography in the federal system has by far the most nuances. It is would be the biggest shock going from how you may have handled child pornography cases in state court to federal court, and a majority of that, which we're going to be discussing, has to do with the sentencing structures between federal and state court, which are vast. I am still, with all the experience I have in this, still learning more and more every day. So this should be a great start, but continue. If this is something that you're interested in and representing clients who are facing such serious charges in federal court, then you really, really have to do your homework. You have to be prepared because these are very, very technical aspects of the law that you deal with in the federal internet crime, cyber sex crime community, so to speak, of charges. So let's jump in. Okay, so state versus federal. Federal courts are governed by the United States Constitution and Title 18 of the United States Code. State courts are governed by both local state laws as well as federal. This does result in several differences that create very large impacts for our clients who are facing federal charges as opposed to state, and again, mostly as it relates to child pornography offenses. A lot of what I'll be talking about is applicable to both, but a lot of what I'm going to be talking about are, the specific nuances in federal court. The outcomes when a case does go federal are drastic when it relates to sex crimes in general, because the sentencing structure, the resources that the federal government has are vast, far beyond what local law enforcement or state law enforcement has, as well as the technical technology that is available to the FBI and is available to Homeland Security and DEA, whoever might be investigating this case or a federal sex crime. So very, very, very important to consider these things when deciding whether or not you want to take on the endeavor of doing federal sex crimes in court, in federal court specifically. So the laws do overlap. The U.S. Constitution does give federal courts basically the last say. And what's interesting about that too is that federal courts ultimately, and federal prosecutor's office, whether it's the U.S. Attorney's Office or if it's Main Justice and Department of Justice based out of Washington, they get to pick and choose what cases they want to bring. And it's really important when you're thinking about federal sex crimes. How do we determine that? How do they pick and choose? Because going back to what I believe my partner Adam had said, this whole process of criminal representation starts at the initial meeting with the client, and you have to be able to set your client's expectations. There are very few charges, and child pornography being probably the most common, along with maybe felon in possession of a firearm state charges that have a, I would say, high likelihood, depending on the facts of the specific case, as to whether or not the feds are going to come in, even sometimes after state, local law enforcement has investigated a state crime related to child pornography, and charges have been brought in state court, and then the feds will come in and they'll say, actually, no, that's a case that we would like to take. And we're going to talk about the reasons why they would do that. but something that I always love to do when I get a case, and if the case comes to me, because a lot of cases do start with state investigations and sometimes even state charges. Well, to me, if you do your homework and if you have the experience, you can kind of get to a point where you can see, is this a case that I should be worried as the attorney about the feds picking up? And if so, if the feds do pick up the case, you have to be able to inform your client about the repercussions of that will be, because for sex crimes specifically, they are drastic. And there are specific reasons we're going to talk about why the feds pick up certain sex crimes that a state court could prosecute as well, mostly as it relates to child pornography again, because some of the other crimes that we see in federal court are a bit more obvious as to why they would. For example, if an individual, if our client is alleged to have been attempting to solicit a minor in another state for sexual activity or sexual exploitation, and they cross state lines to attempt to go meet that minor for the purpose of engaging in a sexual act, whether it's a federal act or a state act, according to the statute, that's pretty clear why the feds would pick it up, because crossing state lines. Okay, but it's not always so clear when it comes to cases involving the internet, and the main reason for that is because the internet is the internet, and the internet is vast. Okay, I don't have to belittle that point. It's global. There's so much technology in play. Experts are so important in this case. I'm not going to try and, you as the attorney have to know enough that you can speak like an expert to your client, but at the end of the day, when you're getting so technical with technology that are involved in these internet cybercrime cases in federal court, having an expert to assist you is extremely important. But again, when it comes to the internet, it's kind of like the Wild West. You may have heard of the dark web, different chats, apps, Discord, Kick, all kinds of different online forums where people can share information. One of the big ones that we're dealing with right now, and we're going to talk about some more, is peer-to-peer networks, what maybe we used to, the primary ones being Napster or LimeWire back in the day. There are other versions, and even actually not LimeWire itself is making a comeback, and what we call peer-to-peer is becoming a huge, huge challenge for child pornography, sexual exploitation defenses in federal court, because the feds do have the opportunity to infiltrate those, and that raises a lot of concerns that we're going to talk about. Typically, when we're talking about, again, how do the feds pick and choose, really, there are certain general tenets of federal prosecution and federal charging decisions when a prosecutor is reviewing a case, a federal prosecutor, and saying, is this one that I want to charge on top of the state court having charged them? Basic tenets is, first, would picking up this case, would proceeding with this prosecution serve a substantial federal interest? That is tied directly into sentencing of federal cases and the enhancements, the guidelines that we will be speaking about later. Every child pornography case that involves the internet is almost always going to meet that criteria, because the feds are very overwhelmed with these cases. They're growing as the internet grows, as the dark web grows, as just the access that people have to each other over the internet in all different kinds of forums and ways. The amount of prosecutions being brought for child pornography offenses in federal court are growing, and the system is adapting, but not in every way that you would expect. A little cliffhanger. Anything involving interstate interstate communications. So it's more clear if we have a child pornography case that involves distribution or transportation of child pornography across state lines, which when we're talking about the internet is usually pretty easy for the government to establish. Not always, but pretty easy. It's much more easy if someone's going into another state to meet with a potential alleged victim or is alleged to have gone across a state to meet with somebody for a sexual act or to entice them or at least attempt to. A little more clear why the feds would get involved. But more than anything, when distinguishing between state and federal sex crimes, it's really about, can the case itself, is it so substantial, is the evidence of child pornography so substantial that it will qualify for the vastly stricter sentencing scheme, including minimum mandatory penalties, that is offered by the federal sentencing structure, both in the sentencing code, which sets the minimum and maximum penalties, and then also the United States guidelines is a separate sentencing structure that we have in federal court, which is more of a mathematical computation. Cases that I see that start off in state court or that I see the feds picking up in the realm of federal sex crimes or child pornography in particular are usually involving a lot of videos, because that meets a certain sentencing enhancement under the guidelines, which we'll talk about a bit more. The number, the content of the videos, the age of the minors that are present in these videos or images, the type of device involved, whether it was a mass distribution, any kind of case involving distribution or a scheme to distribute child pornography, we're already pretty much getting into the realm of federal. And also whether the case just basically has enough where the federal sentencing is going to be so much higher. And we wish it wasn't that way, of course, as defense attorneys. But in general, when they see a case that might be in state court that says, look, majority of state court child pornography offenses are third-degree felonies. In the state of Florida, that's punishable by 5 years. In federal court, the same charge, if there are enough images, if the material fits within these aggravators, these specific circumstances, such as the material involves pain or torture, or sadist or masochism, these different enhancements that exist and will go through them, then they're much more likely to bring that, because they're saying, look, this individual in state court could very likely, if it's their first offense, get maybe probation and sex offender treatment for this. At the same time, in federal court, we're talking about years in prison, possibly even involving minimum mandatories. For example, state courts do not have any minimum mandatory sentencing. A minimum mandatory sentence is where the judge does not have discretion if a certain charge is met or certain factors are met under a sentencing code to give any less. These really don't exist in state court for child pornography offenses. In federal court, almost all child pornography offenses have minimum mandatory sentences. The maximums in state court, usually 5 years. The maximums in federal court can be anywhere from 20 years in majority of cases, upwards of life, depending on a person's history, depending on the specific sentencing aggravators that are in place. Okay, so again, all reasons, things to consider, things to know about why a federal sex crime might go federal as opposed to state. Also, something I want to address quickly is how do these, and we're going to talk about investigations a bit more, but how do these cases come about, okay? And I say cyber, okay? Cyber is basically the concept of internet, easy for them to say cyber, federal territory. Okay. Now, National Center for Missing and Exploited Children. This is a very common way that any case, state or federal investigations or prosecutions into federal sex crimes, specifically involving the sexual exploitation of minors or materials that are created based on the sexual exploitation of minors, such as child pornography. We call it NCMEC, is National Center for Missing and Exploited Children, is a huge factor here. So what happens with NCMEC is a cyber tip, which is an investigative lead, is generated by NCMEC. NCMEC is a nonprofit organization. It provides services nationwide, nationwide, for the purpose of trying to protect children and to weed out child pornography on the internet. There are federal statutes that say that NCMEC has specific mission, and that internet service providers, whether it be Google, Yahoo, all different kinds of providers, have a federal responsibility. Any electronic communication service provider that obtains knowledge, and they do this by different ways, that obtains knowledge, of a child pornographic image being on their site, or that they come across it when they're doing their standard reviews, which every single internet company, Google, they have to do this. If they come across this, they have to report this to NCMEC. They have no choice. What happens then is that NCMEC has a massive, massive database of child pornography images. NCMEC runs whatever Google has sent them, across their database, and then that's when the process really begins. Because it's actually a penalty, a federal criminal offense, for an electronic or internet service provider not to provide information related to a NCMEC cyber tip. So super, super important to understand how NCMEC works, because you're going to see this as the beginning of almost all of your federal child pornography cases. So, as I kind of already said before, federal courts are likely to take cases where a crime involved activity that crossed state lines, including the use of the internet. The other major charges that we see in cases like this are buying or selling children, not the most common charge for the purpose of sexual exploitation. Online solicitation of a minor is a big one, especially if the individuals are across state charge. This is if you think of To Catch a Predator. That's technology has kind of weeded that out, and there's been a lot of issues with that, but that's the traditional online solicitation of a minor circumstance that we see, and it still goes on very often today. And we can talk about that a bit more. There is still traditional sex crimes, such as aggravated sexual abuse, rape, other charges that can be federal. Usually it involves some sort of involvement with interstate commerce or interstate travel, crossing state lines, still going to meet somebody somewhere. All right. Otherwise, we're really talking about much more likely staying within state court jurisdiction for that. One of the biggest difficulties, again, one of the primary crimes that we're talking about: child pornography, online solicitation of a minor, sex trafficking. Sex trafficking of minors in particular is still a rare charge, but it is one of the most serious charges that we see. And if it's crossing state borders, if these children are being brought or enticed across state borders, and these include attempt as well, even if the child is never brought, even if the person on the other end is a undercover officer, sex trafficking of minors is a major, major federal offense. Very difficult to defend against. We do it successfully, but the penalties in federal court are very, very severe for these offenses. Another thing about dealing with federal sex crimes and differentiating from state court is this process of the grand jury. So in federal court, you need a grand jury investigation. Okay, you have to be able to produce an indictment from a grand jury in order to bring criminal charges. That is unless you're a defense attorney, unless myself and my client have been notified early enough. If an investigation started early, best case scenario, when our clients have an opportunity to proactively come and seek us out and say, look, I was contacted by an FBI agent who wanted to come and speak to me about something that he saw on my phone, or a cyber tip that he had received from NCMEC or from Google. And that can happen in so many different ways that we'll talk about. But to obtain a grand jury investigation, state court, state court prosecutors, the amount of investigation that has to be done, it's not even remotely the same, because there's still sufficient investigation, definitely sufficient investigation. But once the prosecutor is given the investigation over to them by the investigator, whether it was a sheriff, or a detective, a lot of detectives are part of, even in state court cases, are part of what's known as ICAC unit. ICAC is it's Internet Crimes Against Children. There is a very large national task force that exists, which a lot of the detectives we deal with in state court, and a lot of the FBI agents that we deal with in federal court are both part of ICAC. And what that is, it's a collaborative collaboration between state and federal law enforcement for the purpose of protecting children and protecting and stopping human trafficking. It's kind of a human trafficking task force in and of itself. So ICAC, even if it's on a state level, they have substantial resources, very substantial resources. It's something that we have to deal with, both in state and federal cases. But this investigation that is completed here, if it's going to federal court, then there has to be enough, and grand juries kind of are rubber stamps. There just has to be a reasonable likelihood of conviction. The defense attorney is not involved whatsoever, but they do have to have enough information already through the investigation to bring it to a grand jury to get charges, and not get embarrassed as a federal prosecutor by not being able to get a grand jury. So what that means is that by the time a case is charged in federal court, the case is very, very underway, usually. And there's a lot of strong evidence, because a grand jury of our peers has already reviewed the evidence and decided that there's enough, as opposed to in state court, just the prosecutor reviewing it and signing off on what's called an information or a charge in that way. So the reason we're going to have a major focus on child pornography here is because it is one of the most prominent federal offenses, period. It also happens to be a sex crime, which is the purpose of our investigation today. There is a significant amount of data, which is very helpful to defense attorneys, very helpful regarding child pornography. In 2021, which is the most recent report, which is provided directly by the United States Sentencing Commission, and they are the ones who reform and make the United States sentencing guidelines. It's by far the most common federal offense. It's been consistent like that for a while. Just as a stat here, roughly 58,000 total federal offenses reported in 2021. 2.1% of all offenses were child pornography. That's a huge number. There's thousands of federal crimes. So we're talking about here only drug offenses, immigration offenses, firearms offenses, fraud offenses, and robbery had more. And robbery kind of goes back and forth, but we're right there as far as federal sex crimes, specifically child pornography offenses. That's a huge portion of the total cases that are being prosecuted in federal court. So talking about the types of child pornography offenses generally, being that child pornography is going to be our focus here. We have Title 18 of the United States, the United States Code. I believe it's Section 116, 110, 116. 1 second, let me not get that wrong. 110, excuse me, 110. So 110 lays out the child pornography offenses that we have. And what we are focusing on here is possession, creation, which we call production, distribution, transportation of child pornography. Now, I could spend 5 hours breaking down each individual statute. Okay, federal law prohibits variety of offenses as it relates specifically to child pornography. These are the major categories that we deal with. Okay, distribution is the one that is most interesting. There's been the most debate for decades regarding because of some things we'll talk about in the way that the language is written in the statute and the way it's interpreted in the guidelines. Distribution and receipt, as well as possession. Possession, of course, is the kind of the big one in general and the most prevalent for mostly as it relates to sentencing reasons. It does have the most opportunity for lighter sentence in federal court, and it's far from light in the way that the sentencing code works and the way the guidelines work. But then once we get down and break it further, we're talking about two overall main categories, which is non-production offenses and production offenses. And it is very important to understand the differences and the nuances between these two types of offenses, and the way that the guidelines, the sentencing guidelines, work when we're talking about non-production and production offenses, mostly even further the way that the non-production offenses break down. Okay, when we're talking about the guidelines, it's 2G 2.2 for non-production offenses and 2G 2.1 for what's known as sexually exploiting a minor by production of sexually explicit visual or printed materials. That's basically production. Okay, production is not as common. It is much harder to defend for the purposes that we're dealing in federal court. The mandatory minimum sentences for production are outrageous, just as they are for non-production. Now, one could say that maybe in production, and we're talking about production, really what we're talking about is actually creating child pornography, not possessing it, not sharing it. Very often, individuals who are charged with production are also charged with possession and distribution, sometimes receipt. But production, we're talking about the individual is alleged, our client is alleged to have actually either himself been the subject of an image where an alleged explicit sexual conduct is occurring with a minor, or they were involved in the creation of child pornography, sexual exploitation materials, or child pornography. I mentioned here at the bottom the 2012 child pornography report and the 2021 updated report. These are extremely important. They're available if you go to the United Sentencing Commission website. You can read these reports. The reason these reports were created in 2003, and this leads us kind of into just the myriad problems with the federal sentencing code as it relates to child pornography offenses. Because in 2003, there was an act called the PROTECT Act that was passed. What the Congress, lawmakers, and judges were seeing was that the laws related to child pornography were not keeping up with the technology that was beginning to boom in the early 2000s. So what they did in 2003 is there was a massive nationwide among lawmakers, judges, defense attorneys, prosecutors, politicians to reform the entire child pornography sentencing structure. They came up with the PROTECT Act. That is what creates all of the guidelines that we fight against today in child pornography, sexual exploitation, material cases in federal court. Here's the problem. This act, these guidelines were created in 2003 because the technology was just growing. Now, okay, and starting in 2012, when they made the child pornography report, which is available online, you can reach out to me for a link to it. If you can't find it, I think I'll be able to screen share on here as well to show you what it looks like and how to find it towards the end. But in 2012, all these same lawmakers, the judges, defense attorneys, prosecutors got back together, human rights, civil rights organizations, and said, look, it's 2012 now. Everything that you did in 2003 when you created the federal sentencing structure is now too harsh, because technology has now gotten to a point where when you created certain enhancements, like there's an enhancement to this day for +2 points on your guidelines, on your potential score and your punishment in federal court for use of a computer. In 2003, that might have made sense, because prior to 2003, distribution of child pornography might have been mailing pictures and images to individuals that you bought at an illicit store, or that you obtained from other matters not involving a computer, and you mail. But when the boom of the internet, it's like, okay, at that time it made sense. We have to punish people because we don't want people using these new fancy computers to distribute and to possess child pornography. Now it's become the opposite. Now the huge problem with these same individuals, these same groups of people who, other than defense attorneys, because we never agreed with the PROTECT Act, but the same groups of individuals who supported it are now coming back and saying, look, we're giving people, defendants are being hit with these massive guidelines that made sense in 2003 but don't make sense anymore. And the 2012 Child Pornography Report, it's called, authored by the United States Sentencing Commission, did find that the 2003 PROTECT Act guidelines and sentencing structure is extremely out of date, and it's bad. And 2012, then we get to 2021, where an updated report was produced. What has changed since 2012? And nothing has changed. This is something that we fight about as defense attorneys who do this. You have to be aware of this for your clients, because it's a huge part of every aspect of the case. There is no other federal offense, nothing even close, where there is so much litigation about the policy behind the sentencing structure itself and the guidelines, especially the mandatory minimum sentences that the PROTECT Act created for distribution and receipt offenses of child pornography. We're talking about 5-year minimum, 20-year maximum. If you have any criminal history, that goes up to 15 years minimum and 40 maximum. I mean, these are huge penalties for crimes that usually, statistically, which these reports break it down for you, but I'll tell you generally, involve first-time offenders and involve very good people. I mean, we at our firm believe that all of our clients are good people. We help good people when bad things happen to them. We've worked extensively in child pornography and sex crime cases, more than any case, with forensic, psychosexual, neuropsychologists to form evaluations for us about what causes a person to engage in this behavior. And what we're finding is it's not that they just woke up one day and said, hey, I'd like to look at child pornography. There are underlying traumas, okay? There are things from childhood that were never addressed. There are legitimate mental illnesses recognized by the DSM-4 and DSM-5. Pedophilia, it's not something that people ask for. It's a disease. And these guidelines are so harsh and don't take that into consideration. Now, 3553 of the Sentencing Code, which we have another federal CLE on federal sentencing in particular. I've made YouTube videos about it. You can reach out to me about how the code works. It basically allows someone to be viewed as a human and consider these things about their nature, which they take into account. They're so important to know in these guidelines that were created by the 2003 Act and today are simply draconian and archaic, have not been changed. We as defense attorneys have a responsibility to fight to change them, and that's what we're going to do. Okay, so going into child pornography non-production offenses, the main ones we're talking about is receipt, possession, and distribution. Okay, and these are the general categories because these are how the guidelines consider what the appropriate penalties are. There's about 7 different statutes within 18 U.S.C. 225A2 and 225-2A that describe each statutory penalty and the minimums and maximums. But at the end of the day, receipt, possession, and distribution is how the courts and how practitioners, deal with these cases. So going back just a bit, child pornography is defined by federal law as any visual depiction, including photograph, film, video, picture, computer-generated images of sexually explicit conduct, and that's in person, involving a person under the age of 18. Now, sexually explicit conduct is actual or simulated sexual intercourse, bestiality, masturbation, sadistic or masochistic abuse, lascivious exhibition of the genitals or pubic area, and which is done so in a lewd or lascivious manner, okay? And just to keep in mind as well that these videos and these images that we deal with do not have to involve an actual sex act. It could be a display of a minor's private parts in a lewd or lascivious manner, which is one of the things that we attack on these cases very often. So, primary types of non-production offenses. Okay? Distribution and receipt both carry a 5-year minimum mandatory. That means that if you're convicted of distribution or receipt, then you are doing at least 5 years, and the judge doesn't have discretion to do less unless you do something called substantially cooperate with the government. Less than 2% of federal child pornography cases result in substantial assistance. I did have a case that had one because my client was kind of unknowingly involved. He was charged with distribution and receipt and possession, and he was unknowingly involved in a very large organized ring of mass child pornography distributors in Philadelphia. This was a case in Southern District of Florida where my client resided. We're talking about millions and millions of images and videos that a group of individuals in Philadelphia were distributing, and my client had the opportunity. I was able to speak to him from the initial interview, review the filings quick, get to the prosecutor quick and say, look, my client actually here, even though he's facing a minimum mandatory, does have the ability to cooperate. And he was able to beat his minimum mandatory because he gave consent to the federal government to use, prior to him being charged, to use his identity and then they went on using his identity and continued building their case against these individuals and across in another state who had a nationwide operation, and it worked out phenomenally. But that's very, very rare in child pornography cases, where mostly we're dealing with most commonly someone who's involved in a peer-to-peer network, such as LimeWire or the equivalents, and other common peer-to-peer sources that are out there. Dealing with the dark web is common. Certain apps, there are Mega, and a lot of apps that you'll see. I'm not going to go into every single one here. You can message me if you have questions about that, or ask questions about what are the most common apps or electronic types of devices that we see where people are exchanging or possessing. Peer-to-peer we'll focus on, because that raises particular concern when it comes to child pornography. So again, the reason why we focus on receipt, possession, and distribution is really because of how draconian and how convoluted the guidelines, sentencing guidelines in federal court are when it relates to them. For example, just as one example, the base offense level in the federal sentencing system, you have sentencing guidelines. Base level starting points for possession is 18. Starting points for receipt or distribution is 22. But if your receipt did not involve distribution, you get 2 points off. There are specific enhancements for distribution built within receipt and distribution. We've tried as defense attorneys, and keep trying on your end. I'm going to keep trying. Our firm's going to keep trying to argue that this idea of including distribution enhancements within a crime of distribution itself is, if not double jeopardy, draconian. And the government has found many ways, case law that has been created to get around that by making the statutes themselves in the sentencing code and in the United States Code, very, very broad. But it's pretty awful what happens here. So especially when it comes to distribution offenses and the way the guidelines work, with the technology that we have today, there's so much questioning. I litigate so much. Our firm does. Other lawyers who really just can't stand and feel passionate about what is happening to individuals who, with child pornography federal cases, are facing worse sentences in a lot of cases than people who commit very violent crimes. Not that they're still not good people. All of our clients are, as I've said, but just is shocking in a lot of cases. So, for example, in distribution, the item being distributed in a distribution case, a matter of child pornography, has to be available to someone other than the person who sent the materials. The individual, our client, has to be aware that he was, if using a peer-to-peer network, was sharing this folder, which is a whole other matter in and of itself. When you're dealing with peer-to-peer, I could do a whole presentation on peer-to-peer and the technology behind it. If my client is using a peer-to-peer network and does not realize that his setting on LimeWire, whatever similar network he's using, is open, and he downloads a file that he or she downloads a file that is adult pornography, 3,000 videos or images come in, and there's no obvious indicators like hashtags saying, prepubescent female, torture of minor, things along these lines that would just make it much more obvious that this was, in fact, someone, even if they're using a peer-to-peer, you have a hard argument at trial to say then that, oh, they didn't know that this was in fact child pornography when they received it, that becomes a little bit tough. Number of files, the file names, baby. I mean, there's some horrible things that we see: baby, anal, rape, young girl sex, things along these lines. Makes it a little harder to say that. But then you also have to go and you have to see, can the prosecutor actually get this evidence into a courtroom in the first place, which is a whole other topic. So again, federal sentencing and non-production cases, it's very difficult. What we need to concern ourselves, most importantly, you need to understand the guidelines and the enhancements very, very well and very clearly. But what we're generally talking about, without getting too specific with the numbers and everything, is what about the images and the videos can kick in certain enhancements, okay? The quality in the image of the videos, the age of the victim or the alleged victim in the video, gender, okay? How child pornography received, what method was it received, what method was it distributed, where was it stored, was it concealed in a sophisticated manner, because there's really, I would say, these 6 enhancements that apply every single case, which makes them all the more draconian, that we have to fight against as defense attorneys. The primary enhancements from the guidelines being a victim under the age of 12 or prepubescent, whether distribution occurred and to what level distribution occurred, whether the images included sadistic or masochistic acts or violence, or the exploitation of an infant or a toddler, okay? All of these things, these categories, the defendant engaged in a pattern of activity involving the sexual abuse or exploitation, the defendant used a computer, the offense involved a certain number of images. These 6 enhancements to sentencing are found in over 78% of all federal child pornography cases. Why is that? Because the feds picked it up in the first place. And when the feds pick up a case, it's because they want to know that they're going to hit all of these aggravators. I mean, it's a fact, okay? We've learned it from prosecutors. We've heard judges mention it. It's in legal writings. I suggest that the guidelines itself are regarding child pornography offenses. It's probably about 40 pages long, so I can't go into all of them. There is a significant amount of case law regarding when these guidelines should apply and when they don't apply, which we can go into. You can reach out to me separate. You'll have my information. I have a lot of resources, all of the case law on how to challenge these guidelines. A very common one that we challenge is, can they actually prove that the victim was under 12? How do they do that? We make them bring in an expert. Okay, was the focus of the video explicit sexual conduct? Okay, or was it child erotica, which is also a nude image of a minor, but not in a sexually explicit manner. Now, the base sexual explicit manner that the government says and the statute says is a specific focus on a unnatural specific focus on the genitals is basically the bare threshold for a child pornography offense. But sadistic or masochistic act, that guideline or that aggravator, there's so much cases about what constitutes sadistic or masochistic, which is basically causing pain or torture. The courts have kind of killed defense attorneys on that, but we still fight it. They basically said that any infant, anyone under the age of 12, but especially any prepubescent minor who is being vaginally or anally penetrated, it is assumed that they are suffering pain. But there is case law to the contrary as well. Again, we don't have time to go through all of it, but each of these guidelines, you have to, even though they're so common, you have to argue them. you have to argue that if your client is charged with possession, then why should he get a distribution enhancement if he's not being charged with distribution? Okay, now you want to be careful about that, because then you don't want the prosecutor to go back and say, well, I'll just charge him with distribution. There's so much convoluted aspects of this that you just really need to pay really specific focus on and master the guidelines. And I'd be happy to provide you with those materials. As far as production offenses go, I'm not going to spend too much time on them. Production offenses carry a mandatory minimum term of 15 years, a max of 30. If there's any prior convictions, we're talking then about 25 minimum years, day for day, and a maximum of 50. And then if we have a third offense, we're talking about 35 years as far as a minimum, and life in prison as a maximum. Production offenses are very, very serious. You want to understand the nuances and the guidelines that are associated with production offenses, because these cases are tough. They're serious. You want to set expectations in these cases with your client very soon, but there are absolutely defenses to production cases. There are situations where the government may say you induced child pornography by having a video and taking a screenshot video, an image of child pornography. We fight that. Okay, we fight that. There are things to fight here. You just have to know the nuances, know the guidelines, and know the case law very well. So the stages of a federal child pornography charge: you have the investigation, the charging, similar to what the previous aspects of the program, the CLE, has discussed. The sentencing, obviously, as we said, is the most unique. The way that these points, these extra points, depending on these aggravating factors, come into play and how you fight those. I think probably the most important thing to consider with this is that sentencing disparity, this is federal, okay? No one's going to really fault a judge in Iowa from giving probation for a child pornography case when a judge in Florida might give in state court 5 years. Iowa and it's Florida. Federal is supposed to be standard, okay? Sentencing disparity is a huge aspect of federal sentencing. So that's where, and if you read these numbers, if you read these reports that have the statistics that I advise that you read, the 2012, especially the 2021 report offered by the Sentencing Commission, you'll see that individuals who get charged with possession but have the same exact, ultimately the same guidelines as receipt minus the minimum mandatory, the amount of sentencing we're seeing across the country, even in possession, simple possession cases themselves, literally range from 0 days in jail to 270 months. Okay, these are massive discrepancies. When you do a federal sentencing in a child pornography case, you have to be prepared to argue the disparities. Cases from what that judge has done. It's all on Pacer. Go out there, find the cases in different courtrooms with similar facts. I have a long list of cases for the Southern District of Florida. I'd be happy to provide it to you if you want to email me. Probably about 50 lists with the standard possession, distribution, receipt kind of usual fact pattern, usual guidelines, and the disparity in the cases that we're seeing. The judges are recognizing this because variances from the sentencing guidelines, from what the guidelines in the United States Sentencing Commission recommend sentencing to, a judge to give a sentence to, variances are very common, more so probably than any other federal offense, because there is so much policy, there's been so much debate, it's still ongoing, and judges know that because they're involved in it. When they're thinking, every case these days involves 600 or more images or video. Each video, by the way, constitutes 75 images. Okay, so if you have, I think, 8 videos, you've already met that, and then you get 5 additional points on your sentencing guidelines. The judges know this. You have to be prepared to argue at sentencing the draconian nature of the sentencing guidelines. As far as plea negotiations in federal sex crime and specifically child pornography, you want to always try to get a plea to possession because it does not have a minimum mandatory sentence. Please go for possession. Receipt, distribution are very similar. The guidelines change a couple points, but possession is where we think far more than it ever should be for a majority of these cases, especially given the circumstances. If it was a peer-to-peer network and the individual didn't realize that this file they had that they thought was adult pornography was included child pornography, and then the feds are using their software, I believe it's called Mole or eMole, where they go on and they just look through these files and say, oh, this file has child pornography in it, and this is the IP address, we got them. It's not right. It's not right. So common defenses of federal child pornography cases, peer-to-peer networks, you have to understand the nuances and the way the technology behind peer-to-peer networks and how they work. You really should have an expert to do this if this is one of your first cases. Experienced attorneys like us understand how peer-to-peer networks work very well. It is a defense to a federal child pornography crime if you possess less than 3 images or videos and or report right away to law enforcement that you accidentally came upon these videos. Pretty rare, but it does happen. Lack of intent. That goes back to a lot of what I'm talking about with peer-to-peer, which is the big point of debate now. People can get big files, and if the evidence doesn't show that the file is so obviously containing child pornography, they receive it on accident. They clicked on a website and saw that it was not, it was child pornography. It was not what they were looking for. They did not intend to receive child pornography, because for a receipt under that statute, you actually have to have specifically intended to receive child pornography. Make sure that's something that you always defend. It's not like possession, where just being in possession of it can be a crime, as long as they can prove that you knew, or should have known that it was based on circumstantial evidence that you possessed child pornography. But receipt, specifically requesting it, make sure that you challenge that. Like in all of the cases we talked about, misconduct by law enforcement, issues with the search warrant, issues with the cyber tip from Google, or issues with the tip and the information that NECMEC received, very important. Attacking the technology itself, Cellbrite, the software, Griffi, these softwares you'll hear about that the government uses to process, if they get somebody's phone and they do a phone dump, see if there was issues with the service. You have to do an evidence view in these cases. You have to go to law enforcement, to the FBI headquarters, wherever it might be, in South Florida, it's Miramar, and say, I need to see these photographs, And more importantly than the photographs, this is the biggest tip I could probably give you. So many attorneys, federal attorneys, will go and say, let me see the photos. Oh my God, there's babies being anally raped. My client is screwed. No, that might make out enough for an aggravator. So when you go to see the images, is it horrible? Yes, of course. Get a different job if you don't want to go and deal with this. You need to fight with your client, or don't take into cases. When you go to do the evidence view, you need to see the photos to the extent. What I do when I go, I say, please create a separate file, where you can show me how, based on the photo, you would meet each one of the enhancement. Torture, this is that photo. Prepubescent, this is that photo. Thank you. Show me the photo that led to the warrant or led to the cyber tip? Is this sexually explicit conduct for me to see? Yes or no? Thank you. I've seen that, okay? You don't need to go and see all 1,000 videos. What you do need to see and what needs to be provided to you is, of course, all of the reports, the search warrants, the complaint, transcripts of any conversation that were alleged to have been from an undercover with your client engaged in the distribution or agreement to provide child pornography to an undercover, get transcripts of those reports. But really, more than anything, what you need is you need the government, whether it's the FBI agent or the prosecutor there, to show you what's called the sanitized pathways, sanitized forensic report. Not enough lawyers do this. Because the prosecutor won't go give you this right away if you don't request it. They won't. They'll say, come view everything, and you've gotten your evidence view. But what you need to know is you can request, and they have to be able to provide what's called a sanitized forensic report. And this is the report that the agent, or if it's a state detective who's part of the ICAC unit, the report they generate, okay, that shows the pathways. It shows when the video was on the computer or the phone, when was it opened, was a thumbnail created, okay, was a bookmark created, what happened to the video or the photo, was it deleted, was it sent somewhere else, was it put in a different file, where are these photos moving to? They can't give it to you with the alleged child pornography itself. That is distribution of child pornography, and then the attorney is charged with receipt. So that doesn't happen. But they can give you the exact same report that you need, so you can see, can they actually link these photos to your client's 2 mic device that they have seized or that my client voluntarily gave them? Can they link these photos to that device? Okay, that's super important, and you can have that recovery. If you have to go see the images, which you always do, you see the ones you need to see, you see them show you that there is either how many videos and images there are, if they can meet out their 600 or more enhancement sentencing guidelines, so you can tell your client, yes, I did go look and I saw they had more than 600, okay? But get these sanitized reports, get what they have minus the images, they will give it to you. If you have questions specifically how to get it, email me, call me, and call my firm, and we'll tell you exactly what you need to be looking for. But challenge the IP address. Find out if someone else was living in the home that could have accessed this. Was somebody else mooching off of our client's internet? The feds are very good at tracking an IP to the person. Of course, if your client gives a statement, that's another story. And very often our clients this will be their first offense, and they will say, yeah, cops came and they just showed me some photos and they asked me if I had seen them before, and I said yes. So I was terrified and I thought they had me, and I told them yes, no one else uses my computer or my email address. So same as any federal criminal defense, always best case scenario that either your client doesn't give a statement, or if you can find grounds to suppress the statement, you always have to try that. But the software that they use, Cellbrite, which does the phone dump, and then usually Grify, which the lead agent then uses to narrow down their cell phone dump to what they're specifically looking for, the specific videos or images or hashtags. You can get that without the images, and you really have to. So online solicitation of a minor is another charge that we see. 240, 2422, 2423, illegal to use the mail or internet, any form of interstate or international communication to solicit a minor for sex. It's illegal to travel across state lines to meet a minor for sex. One nuance about that, these are pretty straightforward. There are very serious penalties, anywhere from 10 to 30 years in prison, depending on the aggravating circumstances and the priors. Of course, it's more if you created child pornography, if you took a video during this as well. You can be arrested and convicted for soliciting a person you believe was a minor even if she was above legal age. It's about what you believed and what the the defendant's, our client's intentions were. Okay, there are certain rules though when it comes to these offenses regarding solicitation, and enticement is another one that carries with it a 10-year minimum penalty, and that's enticing under these statutes, enticing a minor to commit a sexual act, whether it's a federally prescribed sexual act or a state act. You One thing to always look out for is you can be mistake of their age. You can still be prosecuted and convicted if it's a officer acting as a minor, if it's law enforcement acting as a minor, okay, or if you believe or you know the individual is a minor. But if it just mind, if it is an adult, non-law enforcement who's on there acting as a minor, there are actually exceptions where that's a legal defense because that's not allowed to be grounds for this if it's not an actual minor you're talking to yourself. So a couple defenses, there's a lot of defenses to even just to know the guidelines as they relate to these. Human sex trafficking, not that common, but definitely still important. These are situations where adult individuals are coercing, manipulating, whether through force, coercion, as we said, recruiting, manipulation, in order to provide sexual services, either to themselves, but more commonly to other individuals in order to benefit our client or the defendant. They carry with it minimum mandatory sentences that can be very severe, depending on the number of convictions, depending on how much fraud or force was used. That's another one that we see commonly, and you have to know the nuances. Again, for example, if the prosecutor is able to prove a defendant just played a role in preparing to send a sex trafficker to the United States, they could face a sentence of 7 years. Okay, so you can argue if you feel that the evidence is overwhelming, maybe your client was not, didn't fully complete this. There's kind of an attempt situation here where it's going to result in the full possible sentences that you can face. So again, trying to cram in as much as possible here. The federal sentencing guidelines, federal sex crimes are so nuanced. Reach out to us, read these reports, go on to the sentencing guidelines, type in United States Sentencing Commission reports. There's so many resources there. I still rely on them all the time. I have my clients. It really, really helps. And you have to do this early on because these are not your typical state cases where it's 5 years for a third degree, 15 years for a second degree in Florida. The sentences based on the guidelines can vary so greatly. There's so many minimum mandatories, and you have to understand this so you know how to attack these and fight for your client. So that's it for federal crimes. I believe that now we have a bit of time left. Again, use our QR code, reach out to me to discuss the nuances and discuss how to fight these cases and deal with federal prosecutors in sex crime cases. And I believe the plan now is that we're going to invite all of the attorneys back for a roundtable discussion.
So this would be a great time if anybody has any questions. I think there's only about 6 people who are watching this live. So you've got a lot of brains that you can pick here if anybody wants to ask some questions. But I think that the main thing to really keep in mind is that when you're dealing with a sex crimes, it's to not be intimidated. You know, I know a lot of attorneys who have tried homicide who have never done a sex case because, you know, they have a victim and it's a child and they don't really know what to do with it. I've seen really experienced attorneys who rush through these depots telling the child, you know, I don't want to re-traumatize you. So is everything that you said to the police, is that correct? That is just borderline on malpractice. So I think the really important thing to keep in mind is that you don't want to be intimidated by these. You want to obviously be polite and nice, but you can still advocate fervently for your client without being an a-hole to the child. So, I think that's the number one thing to keep in mind. And when you're cross-examining a child in front of the jury, remember that your client, you're fighting for their life, you're fighting for their freedom. And if your defense is that this child is making it up, it's okay to go a little hard on a kid if their lies are going to put your client behind bars for a 25-year midman on a cap sex bat. So, I've crossed a lot of child victims, and jurors don't necessarily like the children when it seems like they're lying. So, that's the main thing to keep in mind, is just not to be intimidated.
Yeah, I agree. I definitely agree, Mehdi. And I think a lot of attorneys don't realize it until they've done it. They're like, everyone grows up, I couldn't do sex crimes. I couldn't, I have children. How could I, defend someone who is looking at child pornography and these things? And part of it is, yeah, definitely. It's like, listen, if you have the passion for criminal defense, it's going to be there. None of us condone murder. None of us condone these things, but our clients are entitled to their representation. And just like I said in my presentation, find a new job if you're not comfortable with it. And listen, you're not comfortable with it, you can pick and choose, but don't, as Mehdi, as you just said, and I know as everybody at our firm feels, don't rule it out because if you're a great attorney, great attorneys, great people need great attorneys. And these are good people that this happens to. And even if you don't have a defense and you did it, you have no idea if this person doesn't have some massive underlying trauma. Did they have some massive head injury to their frontal lobe when they were young? Nobody wakes up and says, thank God today that I'm a pedophile. Right? And that's why they need attorneys like us, and they need people to be like, it's okay that you are, this happened. No one, it's okay to feel bad for an alleged victim, but you deserve help too. And then, of course, you have the other cases where, for whatever motivations that you discussed in your presentations, I know all of my amazing partners here, that there are lies. There are lies. More in those cases where the state just doesn't do their job, and we can't live in a system where the state or the government doesn't do their job. And that's especially true for sex crimes, I think.
I agree.
Definitely, I agree.
Absolutely.
I agree as well. And once you really learn, hopefully through our presentation today, once you learn the nuances of the sex cases, like Mehdi said and David, don't be afraid. There are, although they're hard, they are triable and winnable cases.
Yeah.
Agreed. And the other thing I wanted to add is, because when people get intimidated by the way that by a child victim, I always think about this one juror that I had. This was on the Candyman case that I was talking about earlier, and she was a social worker. And when I was doing the individual voir dire to each of the jurors, asking them specifically, do you believe that a 10-year-old child can lie about being raped? Right? Because, of course, everyone's going to say, of course, a kid can lie, but to lie about this specifically. And, a lot of the jurors were saying no. And we had this social worker who I wanted to strike from my panel just hearing her profession. And she ended up being on our panel because her response was, absolutely, I have seen this happen. And one of the other jurors said, well, not a 10-year-old. And she said, oh, younger than that. Because that's the reality. Kids can lie about these allegations. And like Adam was saying, we have a lot of clients that are under investigation currently where it turns out that the wife who they're getting a divorce from is all of a sudden the one who's putting these ideas in the kid's head. So you still have that zealous representation that you give. And I think that's really important to just keep in mind and not lose sight of.
Yeah, Mehdi, you're absolutely right. We have a lot of cases that there is something underlying, like as I talked about in my section, where people are using this for a leg up on divorce, child custody, whatever the issue is. And, people is, yes, to, commit a sex crime against somebody is a very, very, very bad thing. But it's also one of the worst possible crimes to be falsely accused of. It is a career and reputation killer. It's a lot different than, than getting into a drunken bar fight and it was self-defense, but the cops got it wrong and arrested you for misdemeanor battery. To be falsely accused of this can absolutely ruins people's, not just, lives, but their, not even a job, a career, their future. It destroys families apart. Imagine, when children are manipulated in these circumstances and situations. It's absolutely heartbreaking when we see these, and it happens way more than
I always say. I always say I would rather, unfortunately, do some jail time than be labeled a sex offender for the rest of my life. There's nothing worse than that.
Absolutely. That's a life sentence, to be labeled a sex offender. And I mean, and also I think it's important, as David said, just like no defense attorney condones murder. I always start voir dire on these cases with saying, ladies and gentlemen of the jury, you do understand that everyone at this defense table, no one here thinks it's okay to rape a child. No one here thinks it's okay to abuse a child. We can't lose track of the fact that they are innocent until proven guilty.
Mm-hmm.
And I think of one of the in a case that I had tried. I didn't say it, but in a voir dire, it's just a nice anecdote. A fantastic public defender in Palm Beach, where he went up. The state did their 20-minute usual spiel, and can you believe reasonable doubt? And he goes up and he starts off and he says, "Listen, ladies and gentlemen, this is a very serious case. So I'm just going to start off and keep it really light. Who here has ever been sexually molested?" It was like, way too, like lighten the mood a little bit. And they responded pretty well. Wasn't the best, but like, look, it's, none of these cases aren't easy to try. That's not the best example. We probably wouldn't use that, but you have to be comfortable in your own skin when you're trying these, because everyone's looking at you. Like, first they're looking at your client, more importantly, saying, like, walking in, oh, sex crime, it's like you're a deviant. I mean, we have clients in the child pornography cases that, we had the sentencing that we had in Fort Lauderdale, where these clients would watch child pornography, and society would say you'd be reviled by them. They didn't know that he did that because he was anally raped and molested by older individuals his whole life. And had so much shame and never thought that he was going to grow up to be an adult and mental illness. That every time he watched it, he would break down and be hysterically crying. And, you have to have the backbone to go up there and say it to the judge. And especially in that case, when the judge was coming back at us for everything, it's like, stand strong. These people need a defense too.
Absolutely. I know I try to, a teacher and that's a hard one too, when you have, obviously, I had a teacher that was accused of sexual battery on a student that I did, and again, I think everything we talked about today and all the tools and like being confident and, realizing that this is your client's life and you need to fight for them.
Absolutely. Well, it doesn't look like we have any other questions. So all of our information is up there. We're happy to talk to anyone through these cases. They're obviously very difficult and we have a lot of experience with them. So feel free to reach out.